is urgent. Means already processed.
RSA of 2022, and in the meantime, I have received a notice wherein on 28 the partition is to be held on. So I filed an IA that effect. Kindly be listed on 27. My lord, pardon. RSA 356 of 2017, my lord. The RSA is against a common. The suit was for the eviction and permanent injunction. So we have succeeded in both the courts below, but still,
What is the urgency?
it is
What
the
is the
year,
urgency?
it is the year of 2017.
Which year?
2017.
2017.
Yes.
June.
I beg your pardon. RSA 297 by 2016. It was also specifically adjourned to 11 it has not yet got. Kindly. One more.
No, one more. Voting.
Your Lordship, this is a transfer petition wherein the petitioner is seeking transfer of CP number 443 from Learned Family Court, Learned Judge Cuttack to Puri Family Court.
So, what is the urgency?
So transfer.
What is the urgency? What is the urgency that you are making it making a mention to get it listed out
petitioner
of
is
the...
unable to because from
No urgency. No urgency. Yes. Anything else?
Supplementary list item number 1 for judgment.
From a conspectus of the analysis made thus, it is clear that the impugned judgments warrant interference by this court. Resultantly, the appeal succeeds and is therefore allowed. The impugned judgments are set aside. The suit of the plaintiff is preliminarily decreed by holding her entitled to 1/3 share out of half share falling to the branch of Debra. Parties are directed to effect partition of the suit properties accordingly amicably, and in the event of their failure to do so, the plaintiff shall be at liberty to effect the same through the process of the court.
Okay.
I've taken the notional partition in this case,
Yeah,
which you have not argued, by the way.
I'm grateful.
You don't have to be grateful. Not a personal thing. Whatever this court feels that justice should be rendered in a manner which the court understands that whether it is has been argued or not. But you have mentioned it in your written note.
Yes, Your Lordship.
You never argued on that. That was the only case. That was the only point in your favor. All other points are.
On the last occasion, Your Lordship, I just mentioned one thing about notional partition that Your Lordship may consider it,
Yes.
and then I incorporated in my written.
Yes.
Oblige, Your Lordship.
Item number 2 for the
This court does not find any illegality or infirmity in the judgments passed by the courts below, so as to be persuaded to interfere therewith. On the contrary, in view of what has been discussed before, this court is inclined to fully concur with the findings so arrived at. In the result, the appeal fails and is therefore dismissed. In the circumstances, there shall be no order as follows.
item number 3 for judgment.
In the result, the writ application is allowed. The impugned order dated 25/6/2009 of the director is hereby quashed. The opposite party authorities, particularly opposite party numbers 1 and 2, are directed to pass necessary orders to 1. Re-petitioner as PT in the college by treating him as the first qualified PT. Second, to grant him notional continuity of service from May 1992. And 3, to adjust opposite party number 6 either in the same college if another post of PT has been created in the meantime for the +3 wing or against a vacancy existing in any other institution of the state. Necessary orders in this regard shall be passed within 2 months from today.
Item number 4 for judgment.
For the foregoing reasons, therefore, the writ application is allowed. The impugned order dated 28/9/2012 is hereby quashed. The Director, Secondary Education and Inspector of Schools, Bhadrak, and directed to pass necessary orders to release the arrear salary of the petitioner for the period from 1 to 21/12/2010 by fixing his pay as a trained Urdu teacher within 2 months from the date of production of certified copy of this judgment by the petitioner.
Item number 5 for judgment.
For the foregoing reasons, therefore, the second appeal is allowed. The impugned judgment passed by the first appellate court is set aside. The matter is remanded to the first appellate court to decide the appeal afresh by again deputing a survey knowing commissioner to the suit property to identify and measure the same properly and to submit report accordingly.
Number 6 for judgment.
Therefore, taking an overall view of the matter and particularly the fact that the petitioner has been deprived by not being engaged against the PH vacancy at the relevant time as also taking note of the fact that the selection process is on for the equivalent post of junior teacher schematic since 2023 with the vacancies not yet filled up. This court is of the considered view that ends of justice would be best served if the petitioner is adjusted against one of such vacancies, with all benefits being given to him prospectively. Further made such engagement shall not be cited as a precedent. The rate application is therefore disposed of in terms of the above directions. Yes.
Item number 7 for judgment.
For the foregoing reasons, therefore, the IA is allowed. It is directed that the petitioner shall be released on interim bail for a period of 3 months from the date of his actual release on such terms and conditions as may be fixed by the court in session over the matter in the aforesaid case, including the following conditions. He shall surrender his passport before the trial court prior to his release. He shall personally appear before the trial court on each date of posting of the case without seeking representation through counsel. He shall furnish his contact number, address, and location details to the trial court as well as the IO at the time of his release from custody. He shall not try to gain over or influence any prosecution witness. After expiry of the aforesaid period of 3 months, the petitioner shall surrender before the court in session over the matter, failing which appropriate warrant may be issued for his production. This bail application. Yes.
Item number 8 for judgment.
For the foregoing reasons, therefore, this court finds that the claim of the petitioner is entirely untimely. The writ application is dismissed, but in the circumstances without any cost.
Item number 9, fresh admission.
That's all.
Item number 10.
My lord, IA number 23724, my lord. Flag B, my lord.
Yes.
File for amendment, my lord.
You want it to be amended?
My lord. The lordship that in the CP proceeding before the lower court, there is a Vijay Kumar Sahu was the judgment of 2, my lord. So in the TRPC, I don't made a party.
He has not been made a party.
I had not made a party. So
What?
that registrar pointed out the defect. File
IA 3237 of 2024. It is prayer for this prayer for amendment of the transfer application has been made to include Vijay Shankar Sahu as opposite party number 2 in the case. Since proposed amendment is formal in nature, the same is allowed. Consolidated transfer application be filed.
he filed for transfer.
Sir, when will you file the consolidated
My lord,
application?
I have filed in today, my lord.
Ah.
In court.
Is filed in court, the same be kept on record. Yes. Oh, recorded 2020. Over, na? So you'll have to file it in the office.
Hello.
We'll take it up next week then now.
Hello.
Incorporate है जो, है ना? Consolidated transfer application be filed in course of the day. List this matter next week for admission.
Item number 11.
Wait, Dhananjay Charan Devera.
है ना? You have made the corrections.
Already given correctors.
Yes.
Item 9.
Wait. Whenever you want, you cannot take up. When I was called out, you were not there. So I passed it over. I said, hell, क्यों करूँ? Wait करूँ.
Item number 12.
Yesterday, one of the matter mirror. The name has been defective. I have already corrected given them.
Yes. Item 12.
Okay.
Alert 12 matter relating to absorption of Gram Rojigar Sevak to the post of accountant cum data entry operator, your lordship. I recommended by the BDO in the performance report, your lordship. The petitioner has been working since 2007, your lordship. But in financial year 2013-14, one vigilance case was registered against me, your lordship. Kindly see the page 21, your lordship. I was entrusted with the 22
That
lakhs,
vigilance case was registered. So
my lord. I was entrusted.
So when was your claim for absorption on the as what do you call that accountant cum data entry operator, was it rejected?
Not rejected.
And then?
Yes, lordship, rejected.
Then?
Others persons has been
So
observed, but my name has not been.
so they'll consider it. Yes,
My lord. In the light of.
let them consider. The limited grievance of the petitioner is that he has been working as Gram Rozgar Sevak. को जगह?
My lord, Gram Rojigar Sevak. My lord.
In कौन सी जगह था?
Mohulpally Gram Panchayat under Turekela block district. Mohulpally,
Mohulpally,
Mohulpatti, your lordship.
Hmm.
Yes, lordship.
Mohulpatti Gram Panchayat
Under Turekela block.
under Turekala block
District
of the in the district of Balangir since 14/12/2007 है क्या तो
Yes.
केवे since 17/12/2007 बोले
17/12/2007.
17/12/2007 his performance report has been forwarded by the block development officer to the CDO come executive officer on 14/3/2024, endorsing the same as satisfactory. In spite of the above, in spite of the above, as many as 195 Gram Rozgar Sevaks of different Gram Panchayats in the district of Balangir,
Yes,
in the
lordship.
district of Balangir, have been absorbed and appointed as accountant cum data entry operator as per order dated 24/7/2024 of the collector cum CEO, Jila Parishad, Balangir. The petitioner's grievance is that his case has not been considered, which he believes to be because of dependency of a vigilance case against him. Stop. In this regard, he cites a judgment passed by this court in the case of
ପଛରେ ପଡିଯାଇଛି
ଆଜ୍ଞା
ଜାଣିନି
Ashish Kumar Devata versus so.
WPC number 5838 of 2004.
ତୋର ସବୁ ମତେ କରିବାକୁ ପଡିବ ସେ ରିସର୍ଚ୍ଚ ଟା ମତେ କରିକି ଦେବାକୁ ପଡିବ ଜାଣିଗଲି ମିଷ୍ଟର ସାହୁ
ମୁଁ ସେଠୁ ଆଣିକି
ନା ମୁଁ ଜାଣିଗଲିଣି ବର୍ତ୍ତମାନ ମତେ କଣ କରିବାକୁ ପଡିବ ମୁଁ ସେ ଅନୁସାରେ କରିଦେବି In the case of Ashish Kumar Devata versus so, where the provisions of such and such rules have been interpreted. Stop. Since no decision on the claim of the petitioner yet been taken, the writ application is disposed of, granting liberty to the petitioner to submit a representation before the collector, some DEO, collector CEOs actually. Collector comes CEO, Jila Parishad Balangir, within 2 weeks. Along with a copy of the judgment passed by this court in Ashish Kumar Devata Supra. On such representation being submitted within the period stipulated, the collector shall consider the same in light of the judgment passed by this court and pass necessary orders in favor of petitioner, if he is otherwise found to be eligible. Within a further period of 1 month.
1 month.
1 month, yes. The writ application is disposed of accordingly.
That 2 weeks maybe 1 month.
He will file that
Yes.
representation within 2 weeks. The disposal will be within 1 month. Yes.
Item note 13.
May I please, your lordship? Here we are challenging the finalization of the selection process of the Hon'Ble helper, my lord. The petitioner has applied substance of the advertisement dated 31/1/2024, my lord, and submitted an online application on 15/2/2024. The opposite party number 3, that is CDPO, they have published the name of the candidate and one another person and invited objection, my lord. The name of the petitioner was at annex, serial number 5, and the other person was at serial number 3.
Where is that notice? Where is that notice inviting objection?
Page 22, my lord.
Page 22, yes. ଏହା ଦ୍ୱାରା ସର୍ବସାଧାରଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଯେ ଅତ୍ର କାର୍ଯ୍ୟାଳୟ ଏତେ ଦୂର ସେ ଆଦରପଡ଼ା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ଇଚ୍ଛୁକ ପ୍ରାର୍ଥୀମାନଙ୍କୁ ଅନଲାଇନ ମାଧ୍ୟମରେ You are Lakshmi Priya.
Lakshmi
Kudada.
my lord, serial number 5.
Yes,
And I have raised objection against serial number 3, Lodita Chakia.
yes.
On the ground of that, the caste certificate she has submitted, that is not valid, my lord.
Then what happened?
Then I have submitted my application under Annexure 5, my lord, to the CDPO
Yes.
to finance the selection process, my lord. Till it is pending. They have not taken any decision on it.
Yes.
If that is to be considered, then the other private party may not be included.
Yes.
If your lordship directs for considering.
I will direct the CDPO. CDPO to know it, sub collector is to consider. What the CDPO will do? Because the selection.
They are not opened.
No, the selection process has not been concluded as yet. That is his grievance,
It appears, yes.
isn't it? So the sub collector is the chairman of the selection committee. Let him consider the objection. The petitioner,
He has
What?
to pray, he has to file one. He has to file one.
it is there.
This
Someone to Shisu because Jojana Adhikari say them forward kar. This will be forwarded. The petitioner applied pursuant to advertisement dated 31/1/2024 for engagement of Anganwadi worker of Adar Pada
Other Pada.
Anganwadi Center. The petitioner submitted her application online. Kiri remit ko huji. না হয়নি টাচ বন্ধ করে আবার খোলো okay last application online on 15/2/2024. The notice was issued on 17/2/2024. 2024 थी 2024 by the CDPO. कौन जगह ना कप्ती पता inviting objections from all concerned. The petitioner's name found place at side of the list of applicants. Stop. The petitioner submitted an objection in respect of the candidate at serial number 3, raising objection with regard to her questioning her caste certificate. Stop. No action was taken thereon. He submitted an objection on 23/2/2024. No action was taken thereon, for which the petitioner again submitted her objection on 11/6/2024, addressed to the CDPO Kaptipada. Stop. It is a grievance that till date no action has been taken to conclude the selection process after taking note of her objection so raised. Stop. Considering the innocuous grievance of the petitioner, the writ application is disposed of with a direction to the CDPO Kaptipada to forward the objection submitted by the petitioner on 23/2/2024 and 11/6/2024 to the sub-collector. Sub-collector to Kaptipada have any Uddara have. Kaptipada. It's a sub-collector Kaptipada. Who shall consider the same in consider and dispose of the same in accordance with law. Further, the selection process for engagement body worker of the center in question shall be finalized within 4 weeks from the date of receipt of the records from the CDPO. Yes. Password.
Item number 9.
Password. Yes.
My lord, the small prayer, my lord. That present petitioner before your lordship is your wife of the opposite party, my lord.
AGA submits that despite communication, the report of the DU, same should not be complied. Same should not be complied with. Place this matter on 28th August. DU be published positively. Okay,
An extra copy of the
Yes, yes, yes.
petition be,
okay.
an extra copy of the
Yes, yes, yes.
petition be served upon the Learned State Council, who shall transmit the same to
What
the
happened?
sub-collector for doing the needful.
Yes, yes. You have to, the sub-collector's office was to serve it.
Yes.
What happened?
Might have been
What might have been, what is the?
forwarded, but they have not intimated back.
Why are they not intimating? This is the High Court order. What are they?
Yeah, that should not have.
Huh? Place this matter on Monday. Place this matter on Monday. The State Council shall apprise this court. As regards,
The Monday.
Tuesday rather, 27th. The State Council shall apprise this court as regards compliance of the order dated 26/7/2024 positively.
Item number 18.
Item, may I pardon? Item 16, your lordship.
હવે પાસ ઓવર ગયેલો બસંત આ મજૂરી આવું એપણ સૌ હબની
State government.
permitted to withdraw.
But I am for the OP number 5.
Item number 19.
May I please, your lord?
Item 19.
The petitioner has filed this writ petition to count the period for which he has served and undergone training for regularization of the services as well as the for career advancement. The facts remain, the petitioner was appointed by Dynastor 1 as a Shiksha Sahib
Yes.
on 3/9/2014. Thereafter, he has joined. In your lordship may see page 20, there is a condition at that point of time that he has not completed CT or BEd. So in clause 15, there is a condition. The engagement is subject to condition for untrained candidate that he will complete required training by 31st March 2015. And thereafter,
Did you complete that training?
yes, my lord, thereafter he has undergone training on 5/8/2015. He has given an application by Dynastor 3, page 24, my lord. He has given an application to the headmaster, which was forwarded immediately, and he has gone for the training. Thereafter, he joined on 6/6/2017 by Dynastor 4, my lord, at page 25.
No, but what is the annexure 3? Let us see that I've been serving in Konkada part.
Konkada.
Yeah, we under Champa block as TGT BSc untrained
Again.
teacher since 4/9/2014. I have been qualified BEd entrance examination which was conducted by Chhattisgarh Professional Board Raipur. Because of training course, I want to leave from high. This is after the period stipulated in the advertisement.
No, man, that has been announced to everybody else.
Acha.
That is not disputed. Setting more period to work on count konna the say what they did thereafter, after joining
Wait, let me understand. You stated I had joined as a TGT Gola as per, but I was on leave from 6/2015 to 2/6/2017 as I had undergone BEd training course at Mahatma Gandhi. After completion of yes.
that has been forwarded to the PO by the headmaster on 5/8/2015 manner. Thereafter, he joined there and completed the course. On 6/6/2017, he joined again
Yes.
after completion. Thereafter, on annexure 5, when he was not allowed to work, he has given a representation to the collector Keonjhar. Thereafter, approached this honorable court. While the application has been given, the representation has been given. Thereafter, so cause notice has been issued why you are unauthorized absent and your application has not been allowed by the concerned authority. Only for that reason, so cause was asked for. And the petitioner approached this honorable court, my lord. After direction of this honorable court, your lordship may see page annexure 8, page 34, my lord. His grievance was considered and it has been directed last page 36, my lord.
Yes.
In view of the above, Sri Smriti Ranjan Behera is hereby allowed to join in his present post at Konkodapata Primary School under Champa block, subject to condition that he will execute a fresh agreement for subsequent 1 year, and no remuneration shall be claimed during the absence period, and the absence period will not be continued for career advancement.
Counter.
For that reason, again, and repetion has been filed.
You succeed, if at all you succeed, Mr. Vishwal, you will only get that notional continuity.
I am only national. I am not getting.
If at all you succeed, we don't know what
into that. Thereafter, I prepared and repetion because given and representation. Thereafter, they have not considered. This one will go directed to consider my representation. They have rejected the same. For that, thereafter, I filed this repetion matter.
Yes.
In the counter affidavit, one line I will show, my lord.
Now, what have they say? What was the ground of rejection of your representation?
Ground of rejection because in a condition in the 2011 circular, there is a condition that annexure 10, my lord. Page 41. Yes. That has been rejected and it has been communicated, my lord.
No. 19.
In the meantime, he has already completed more than 6 years, but his service has not been regularized in view of pendency of this repetion also.
So what was the ground of rejection?
My your lordship may see paragraph page 42, relevant portion of 5.
Yes.
Say,
Place it. Please place it.
That as per terms and conditions laid down at para 9.5 of the resolution dated 6/8/2013, the Shiksha Sahayaka shall be eligible for casual leave of 12 days during 1 calendar year. He shall not be entitled to any other authorized absence beyond the above mentioned period. If she remains absent with permission, and if she doesn't have any authorized leave at his or credit, the proportionate amount from the consolidated remuneration shall be deducted. But the petitioner has undergone BAD training without obtaining prior permission from the appropriate authority, which has violated the terms and conditions. Next paragraph. That Sri Smriti Ranjan Behera was on long absent in the school on 5/8/2015 to 29/5/2018. Man, that is not correct because 6/6/2017 I joined, but they have not allowed me. And yes, after direction of this annual report, they only allowed me up on 29/5/2018 and I joined thereafter. As per the resolution, government, the engagement of Shiksha Sahayaka is on annual contract basis and the contract is renewed subsequently depending on the performance of the candidate. A positive certificate of school management committee in favor of the Shiksha Sahayaka about regular attendance and satisfactory teaching. So the petitioner has violated the terms and conditions. And your lordship, I am showing your lordship there is a condition in the circular by the annexure.
The question is, did you take permission of your authorities while proceeding for BD?
Yes, my lord. I have given it to my headmaster. Headmaster has forwarded it, and because the BD course is going to be start within 2 days, I left the school, and thereafter they did not take any action. Nothing has been intimated to me. And when I joined and given, they did not allow me to continue there. I gave a representation before the collector. At that point, the so-called notice has been issued. And thereafter, my representation has been considered, and I have been allowed to join again. From that date onwards, they are saying. My dear lordship, may see page 1/2 series, page 22.
Yes.
31/1/2014 letter, where it has been stated clause 5, my lord, clause B.
Yes.
No salary / remuneration shall be claimed during the training period, but the period will be counted for career advancements of the Shiksha Sahayaka. Thereafter, again on 26/7/2016, another letter has been issued, same clause. Lordship, yes. But now in the counter affidavit, they have filed, though they have not denied the specifically parvise, they have not denied. My lord, paragraph 8. Married man. Last person. Subject. He will execute a fresh agreement for subsequent 1 year, and no remuneration shall be claimed by the petitioner during the absence period, and the absence period will not be counted for the career advancement service benefit of the Shiksha Sahayaka. Even if I am admitting that that is the, if it is with the law governing the field or the direction of the authority to governing the field, the period 1 year I have worked earlier, that should be taken into consideration for career advancement. I am not claiming any salary, anything else. I have worked for 1 year, thereafter I have given the application which is then forwarded, and thereafter
Where was the application? Where is the proof that it was forwarded?
that nothing has been replied, my lord. Your lords may see.
It is simply there is a seal forwarded will लिखा है headmaster लिखा है.
Forwarded headmaster master.
आप लिखा है कौन हला किसी
चार्ट दिए
सेमती कौन forward है forwarding ଗୋଟେ letter ही ଯାଇଥିବ ନା.
से तांकर पाखरे सेटा थिबो ना मो पाखरे नहीं.
Yes.
He has not replied, sir.
Is the headmaster a party here? The school?
No, headmaster party.
You should have.
Right.
Anyway.
No, headmaster no, district education officer and
This is the second
block
round
education
litigation
officer.
matter. With respect to the first round litigation matter, when there was a direction for acceptance of the joining report, by that time, my lord, the authority considered that case. And his case was considered with certain conditions. Taking into consideration the facts, my lord, what it was previously there in respect of his case. Now, he's particularly he's harping upon that particular annexure 2 series matter. There are two guidelines. One was issued in the year 2014 and another was in the year 2016. These are the guidelines which are issued to the competent authority, that is the BEO, to take an undertaking from the persons with such conditions. Now, here the specific stand of the authorities matter, that BEO was completely ignorant that he had actually gone for the BD training. So, such an undertaking he had never executed. May I be permitted to take your lordship to that particular page number 22-23?
Yes, just now I've seen. But the problem is,
this has been decided to accord permission to untrained Shikha Sahayaks to undergo BD training subject to the following terms and conditions. So these are the conditions which are to be taken into, which are to be there.
There has to be a positive order allowing him to undergo training. Now that is not here, and the headmaster is not a party. The school is not a party. So how will we know whether you are submitted an application, whether it was actually forwarded or not, whether it was...
Everything in the counter affidavit, nowhere it has been stated that
who are they? Who are they?
Because it has been forwarded to BO as per my information.
Your information will not do, Mr. Vishwal. There must be some document showing that...
In the counter affidavit, they have stated so that your lords may paragraph 10, your lords may see.
Paragraph 10.
Yes, ma'am. They are saying the period I have gone for the training, they will not taken it for career advancement.
No, paragraph 10, they have not said that.
Yes, ma'am. After deducting the unauthorized absence period from the due to the petitioner, his case of regulation will be considered after fulfillment of condition letter.
No. What I'm asking is, when you left for left the school for BD training or BD course, you submitted an application, which there is a short endorsement of the headmaster. They're forwarded, but that is not forwarded. Forwarded has to be by a letter. Forwarding letter.
Maybe that is that.
So unless so that is why I say unless you make them a party, or make the headmaster a party.
I will.
So how can we know? How can we know?
May I be permitted? Yes. In the impugned order page number 41. In the impugned order page number 41, madam.
Yes.
That is para number 2.
Yes.
The stand of the BO, it has been recorded, madam, by the authority, and the last line.
But the BDO Champa was ignorant about his BD training. So
my lord, that is the reason, my lord.
Does not appear to have been forwarded. But if it is a case of the headmaster not forwarding it, then he obviously cannot be blamed.
Yes.
That is why I am asking him, if you so desire, if you are so advised, you may implicate the headmaster of that school as a party. From the school records, it will be forthcoming whether you had actually submitted an application or not. If you had actually submitted this application and it is available in their records,
yes, madam.
If it was not forwarded, then it becomes their mistake.
I am also not claiming that period now, my lord. I am
No. How can I pass any order now?
The period previously I have served for 1 year, my lord. That only that may be taken into consideration. No, I am not.
That will not, because the requirement is the requirement is 6 years continuous service.
I have already crossed 6 years, more than 6 years now.
So
they are not also giving me the regulation.
That's a different matter.
No, till now, because pendency of this reputation, they are not giving.
No. That will not come within your the scope of your prayer. So your prayer is to regularize you from the initial date.
Yes,
That is 4/9/2014.
Yes,
That
yes.
will not be permissible here.
Yes.
Unless this gap
Yes.
period is regularized.
Yes, in the counter, my submission in the counter affidavit, nowhere it has been stated this headmaster has not supplied the same.
They cannot say anything about the headmaster.
If at all they have stated, my submission is if at all they have stated in the counter affidavit, then it's something else. Nothing has been stated in the counter.
How can they say so? How can they
When I have
how can they adduce a negative evidence?
I have make an aberment before this honorable court time and again I have submitted my.
But that aberment relates to the headmaster, not to them. They have said in the impute order itself, it says that the BO was
It's
ignorant,
completely ignorant.
completely ignorant about it. Yes, on oral prayer made by learned counsel for the petitioner, the headmaster, co-school,
Konkada
Konkada
Pato.
Pato High School. The Nata school or Nata?
So Konkodapato primary school.
Primary school.
Konkadapat Primary School, Jagata Kono.
Champua.
Champua is impleted as opposite party number 7 in court. Learned counsel for the petitioner is permitted to make effect necessary changes in the cost title in the court. Stop. Issue notice to the opposite party number 7 by speed post, making it returnable within fixing a short returnable date. Requisites be filed within 3 working days. List this matter on
27th September.
on 27th September. Yes. Let them appear, let them file a counter, whatever. Otherwise, how can the court decide? In the absence of any evidence, how can the court decide? Yes. Yes, item 20.
मेरे पासवर्ड खेलते मोटे मिस के स्टार्ट है
Password.
Aye.
All right, password.
item 21
In item 21, I'm appealing for private opposite party number 4.
Who's for the petitioner? Yes.
My counter on my power has not been reflected in the. I have filed my counter on 6/3/24. On consent, I have appealed.
You are appearing for opposite party number?
4.
Mr. Deepak Kumar Sahu was earlier appearing. Your Vakalatama is not there. Dekh lo.
My Bhaglatnama and my counter is not there.
ଥିବ ଏଟା ସ୍କାନ ହେଇନଥିବ। କ୍ଲାସ କରୁ ଦେଖ ନାଇଁ yes
He has given me the consent.
ନାଇଁ ନା ନାଇଁ ଏଥିରେ ବି ସ୍କାନ ରେ ବି ନାହିଁ so let the office find out ହେଲା Sri what is your good name I'm forgetting
PK Ponda.
Sri PK Ponda appears and submits that he has appeared on behalf of opposite party number 4 after obtaining no objection from the previous counsel and he has also filed the counter affidavit. So, neither the Vakalatnama nor the counter is on record. Office to trace out the same and tag it to the case record, indicating the name of Sri Ponda in the cause list. List this matter on 5th September.
interim will continue madam.
Interim order to continue.
Item 22
Item 22.
May please, Your Lordship. The last occasion, Your Lordship directed Learned State to file the counter.
You receive the Paravise comments, so it is
So we have received the Paravise comment, and this is from the District Mission Directorate from the CDM and PHO, madam.
I will read out the previous order.
No, I have.
I am reading it out again for my satisfaction. Mr. Ayardas, learned additional government advocate, submits that he has received the Paravise comments, but he is unable to present the counter as the same is inadequate. He has sought for further instructions. Now, this was passed almost a month ago.
Before coming to this court, I also verified the same. Only thing, my lord.
Why are they not complying with the order of this
No,
court?
here, my lord. Actually,
When we call them to the court, make them personal appearance, there is a criticism of judiciary.
my lord, only
And
one,
this court would not like to harass anybody. You know that. I will never call anybody to the court to humiliate him.
and
I will never do that. But if you will not obey my order,
what I found, my lord, that it is with the mission directorate.
whatever it is,
No.
you find out. That is your lookout.
Mr. Bibhu Prasad Tripathi, my lord, usually appears in this
Yes.
case. And my lord, he has written the letter, the copy of the letter, my lord, as SGA, because he is also the additional government advocate, my lord, to this office. So, actually we have issued a letter, my lord, whether from the mission directorate itself or from the office of the advocate general, my lord, it will be filed. But at any cost, my lord, if they are not going to file, my lord, we will file it. This may be taken in the first week of September, my lord, we will file it.
As requested by Leonard State Council, let this matter on 5th September. 6th September. Counter be filed in the meantime positive.
Positive.
Lordship, interim order to continue.
Interim order to continue.
Yes.
I will serve a copy because it is a government primary school. Headmaster will.
No. You take notice. Let notice go through. Something No, something current.
Item 23.
Deep problem.
It is in your interest that I am saying, Mr. Vishwal.
Yes.
Let notice go. In the regular course, how can the dairy of if the headmaster doesn't come up, still then you have a very weak case. Know it.
Deep problem.
Yes. Item 23.
I am for petition, my lord.
Yes.
This petition hearing concluded. I am file written note of something.
Hearing concluded.
Sir, last question this operation of a fact of a read petition number.
नहीं आप रिटर्न नोट फाइल कर मैंने हियरिंग कंक्लूडिंग
Complete.
ଆଉ ଥରେ ଟିକେ କହିଦିଅନ୍ତୁ କଣଟା କହିଦିଅନ୍ତୁ ମନେ ପଡିଯିବ ଟିକେ ଖାଲି ଜଷ୍ଟ କୁହନ୍ତୁ
Last my lord, opposite party my lord, no 5.
ହଁ ଇଟ ୱାଜ ହର୍ଡ ଇନ ପାର୍ଟ ଆକ୍ଚୁଆଲି ଏଟା ପାଠ ଦେଇକି ଆସିବା କଥା ଦିସ୍ ଇଜ ସମ୍ ଅଫ ଦିସ୍
ମ୍ୟାଟର ହିଁ ଆସିଛି
ପାଠ ଦେଇଛି ଲେଖା ହେଇଛି
ପାଠ ଦେଇକି ଆସିଛି
ପାଠଟା ଏଠି କେମିତି ଆସିଲା ପାଠଟା ଲିଷ୍ଟରେ ଆସିବା କଥା ଭୁଲେଇ ଯାଇଛି ଆସ ଏନିୱେ what is this matter about just briefly say
I am challenging the
ତା ସାଙ୍ଗରେ ଆଉ ଦିଟା ରିଟ୍ ଆପ୍ଲିକେସନ ବି ଆସିଛି there are two other writ applications correct
yes other
last occasion office number 5 submission the suppression of a fact.
no what is the fact କଣ ଅଫିସ suppression of fact CBI ସାନ୍ତରା
Challenging the order dated 13th June 2023 passed by ATM.
is Anganwadi matter
Yes, my lord.
you are challenging annexure 7
Yes, my lord.
Mr. 7.
ହଁ ଲେଖା ହେଇଛି ତାଙ୍କ ପ୍ରେୟାରରେ by the improved appointment order of opposite party number 5 dated so under annexure 7 and the order of the appellate authority
12.
annexure 12 okay annexure 12 will filed by the appellant Sarojini Mahapatra you are Sarojini Mahapatra
Yes, my lord.
challenging the order of engagement issued respondent to you are Rasmita Sahu Mr. Pradhan she failed to submit the recent resident certificate issued by the local Tahsildar by 5 p.m. on 22/9/2016.
May I be permitted?
Yes, please.
On the last occasion, after hearing the counsel for the petitioner, my lord, it was my turn when your lordship adjourned today, my lord, treating as a partner.
That is the method of first the state, then the private opposite party.
Well, in this case, my lord, the annexure 12 order is under challenge.
Annexure 12,
12.
yes.
That the order passed by the appellate authority. Prior to that, my lord, the appellate authority had disposed the case. And while disposing the same, the appellate authority's view was against Rasmita Sahu. And there was a direction to conduct a fresh selection. And that particular order was challenged both by Rasmita Sahu and by Sarojini Mahapatra. And both the cases were taken up together by your lordships, and the common order was passed that once since no opportunity of hearing was granted at the time of hearing the appeal, so matter will be disposed of afresh. So after taking your lordship's liberty in both the cases, my lord, what your lordship had directed in both the cases, this annexure 12 order has been passed. Now here in this case, my lord, at the time of disposal of the present appeal, after hearing the present opposite party, my lord, Rasmita Sahu, what the authority found that admittedly a residential certificate was issued and it was available with Rasmita Sahu, which was issued in the year 2013. She had the certificate with her mother of 2013. After looking at the conditions stipulated in the advertisement, that she has to get a certificate of the she has to produce a residence certificate
Within 6 months.
which has been issued within 6 months. So immediately she applied for it.
She?
Applied for it, my lord. Then, my lord, before the last date, the RI report was there, my lord, declaring the same, on the basis of which later on the residence certificate was issued. So because there was an RI report, but there was a delay on the part of the authorities, that is the concerned Tahsildar, to issue the residency certificate. So along with an undertaking and a copy of the undertaking in the shape of an affidavit, along with a copy of the RI report and the residency certificate which she had with her being issued in the year 2013, she submitted her application. So when we notified the least manner inviting objections, we found that the petitioner, the Rasmita Sahu, is actually more meritorious. But we had, in the remark column, we had indicated that current certificate has not been issued. So after that particular order, my lord, then a decision was taken that the selection process is actually delayed, my lord. Not on account of these two persons, but with respect to getting a clarification in respect of another person. So the selection process was actually delayed for some time. In the meantime, after receiving the original and the current certificate, Rasmita Sahu produced the same before it could be finalized. And taking into consideration that particular certificate, she has been offered with an engagement, and now thereafter, my lord, Rasmita Sahu got the engagement. Now, issue, my lord, as it has been framed by the petitioner, that once there is a specific stipulation that there will be no entertainment of any undertaking, and the documents are to be furnished before the last date of submission, along with the application form, and incomplete documentation, my lord, it will entail the rejection of the application. So the authorities do not have any power to entertain such type of application, residence certificate which has been produced later on. But the views expressed by the appellate authority in this case, my lord, your lordship will come to Annex 12, that with respect to the residential status of the petitioner, it is not in dispute. She has been issued with the certificate since 2013 with the same status. Thereafter, when she knew that it is a requirement to get a certificate within 6 months, immediately she applied. Even though the RI report was concluded and RI report was submitted to the concerned Tahsildar, but there was a delay on the part of the Tahsil office to issue the certificate. For the delay and lapses on the part of the authorities, a more meritorious person should not be discarded.
Yes.
So this is the standard what it has.
Yes, Mr. Karan.
Last date for submission of application was fixed to 22/9/2016. Advertisement was issued on 31/8/2016. There was a condition that certificate should have been obtained prior to 6 months of notification. So soon after publication of advertisement, the Rasmita applied before the Tahsildar Banpur for issuance of certificate, residential certificate.
Date taken. When is the date?
That on the very next day, my lord. So, my lord, date is not mentioned, neither government nor myself. Nobody has a pen, but
No, but the RI report must be having a
that RI report, my lord, government has announced that.
RI reported date of application thibo.
No, nahi ba, seta film koi desan. Hey, lord, so kindly say RI report C/3 annex government counter, page 13, annex C/3. RI report dated 14/9/2016. This report was available with the selection committee, and I submitted this report along with my application. Well, earlier certificate residential certificate issued in the year 2013, along with this Millard's RI report, as well as an affidavit. In the affidavit, I have specifically mentioned, since I have approached the certificate issuing authority, but they have not yet given me, so I am unable to produce it. But from the RI report, it shows I belong to blood Anganwadi operational area. Now, blood question is, if there is no latches on my part, and the latches on the part of the government authority in issuing certificate, why a meritorious student will suffer? This is number one. Number two, let's kindly have a glance to the notification itself.
No, that is all right, but the date of your application is very relevant. Exactly when did you apply? You can take instructions in this regard. Obviously, after the advertisement, I accept it, but there has to be a particular date. It's true that as on the date of advertisement, you are an old certificate.
No, old certificate, but the report is 49, much prior to cut-off date. 49 report, RI report. Last date is 22 now.
RI report cannot be substitute for the resident certificate.
This is the basis on which.
The basis on which the certificate.
Consular used to.
He may accept, he may not accept.
Yes. Yes.
He may. It is always open to the authority. This is not final or binding on him.
But my lord has delivered 2 judgments.
I know. I'm fully aware of my judgments.
Yes, my lord has 2 judgments.
But they're on factual basis. Those judgments, depending on the facts of those cases. In general principle is that the cutoff date cannot be extended. It cannot be relaxed. But here, the court cannot be oblivious to the ground realities. Supposing there is, as you have said and supported by the State Council, that if there is no fault of the petitioner or the private opposite party in obtaining the certificate, even though as on 14/9/2016 report was there.
Yes.
On the very next day also the certificate could have been issued. Since the sub-collector delayed it, the person cannot be blamed. That is his case.
Yeah, my lord has delivered. Relying that 94 Cornell case, my lord has delivered the judgment.
Yes.
Why parties should suffer? A meritorious one should not suffer.
But
it's not a disputed question of fact because I do not belong to Anganwadi.
I would like to know the date. If you can, I'll just keep it to next week.
I'll obtain that.
Yeah. Heard further arguments in part. Let's this matter next week. 3 BP Pradhan, Learned Counsel appearing for the private opposite party number. Opposite party numbers?
Opinion number 3, opinion 5, madam.
Opposite party number 5 shall inform the court as regards the date of application. For grant of residential certificate by his client. Let's this matter next week. And it will come on 30th August. Series.
Item 24. But so far as extension is concerned, my lord has 94, but subsequently 2-3 judgments are there. Cut-off date is not a bar to consider. Direct decision of the Honorable Supreme.
Exactly, direct decision I have relied upon and said that you cannot extend the cut-off date. It varies from facts. It depends on the facts of the case. Like in your case, you can validly make an argument that I was not at fault. What can I do if the authority does not issue me?
On this,
and a court, particularly a constitutional court, cannot remain oblivious.
But that provision is contrary to the guideline. My lord has also indicated the mallards in judgment.
Yes.
That my lord stipulation is contrary to guideline. There is no my lord stipulation in the guideline.
Anyway.
Item 24.
23 ka malegi.
So, 23. Item 16.
Oh, wait.
Hello, item 24, madam.
23 ka malegi. Is it 23? No? Oh. 24.
A transfer of matrimonial suit from Padmapur to Patnagar. And my lord has the last occasion tried to learned court below to obtain the report from whether the opposite party is appearing in court of notice has been issued twice to the opposite party, he is not appearing. And a report also filed by the IIC.
Ask the learned civil judge senior division, ask the court below to furnish the required information by Monday, 27th August. List this matter on 28th August. this order be communicated to the court below. Forthwith by email. Yes. What is the request? Interim order to continue.
Item 25.
25 plus this is a transfer petition.
You are the petitioner.
Plus, and the last occasion no one appeared. That's why I was saying. But this is a transfer.
You are appearing.
Madam, on behalf of Mr. CORAM.
Any chance of settlement?
My lord, here in this case, conciliation was held, that is failed, my lord. There is no chance
What
of.
I have instruction was no chance of reunion, my lords.
No chance of
Reunion, my lords. What I have instruction, what I have.
where is the let us take up the transfer application. So you want it to be transferred from Bhubaneswar to Berhampur?
Berhampur, my lords.
Yes.
Here, my
Plus,
lord, I
no-
have filed counter affidavit. In counter affidavit, annexure C, my lord. The lady has made a complaint before the state commission, wherein she has stated that she was residing at Bhubaneswar Old Town. That is within the jurisdiction of family judge Bhubaneswar. Annexure C, my lord, of my counter affidavit.
She wants it to be, if she is residing at Bhubaneswar, why will she want the case to be transferred to Berhampur? Tell me.
She has stated, my lord, he has narrated the incident.
ମୁଁ ମୋର parents ଙ୍କ
Because
ସହିତ
the-
ରହୁଛି. The only ground is that I have no means to travel.
That
my lords.
happened, my lord, petitioner is, my lord, the opposite party is paying the rent of that house also. I have avowed in my counter affidavit.
No, no, my lords. Annexure A ଯୋଉଟା କହୁଛନ୍ତି ସିଏ ଭଡା ନେଇକି ରହିଥିଲେ ଘର କିଛି ଦିନ ପାଇଁ. ଆମ ପାଇଁ କିଛି rent ଦଉନାହାନ୍ତି.
Para 9 of my counter affidavit. my lord. He is staying in the house of Gyanendra Patnaik. The rent of the said house is 6,500.
If she is not residing there, then you give up that rented house.
My lords, that
You are not bound by that agreement. କିଏ ରହିବେନି ଆପଣ ଭଡା ନେବାକୁ କଣ ବାଧ୍ୟ ନା କଣ? ଟ୍ରାନ୍ସଫର କରିଦେବା ଆପଣ ଭର୍ଚୁଆଲି ଆଫେୟାର କରିବେ। allow କରିଦେବେ।
My lord, permit me to appear through
Virtually?
BC. my lord.
Yes, yes. That will be there.
I pray, my lord, proceeding may be targeted.
Further, last ଲେଖିବି ସବୁ ସରିଲା ପରେ ଲେଖିବ। Further the family judge ଏତେ ମ୍ୟାଟର ଅଛି ସେ କଣ କରିବେ? ସବୁ ଆମେ ଟାର୍ଗେଟ କରିଦବା ଏଠୁ
My lord,
ଏଇଠୁ ଖାଲି ଟାର୍ଗେଟ କରିଦବା ଆଉ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟର ଖୁସି ପାଇଁ କିନ୍ତୁ
ନା,
ସେ
ଖୁସି ମାନେ-
ସେ ଜୁଡିସିଆଲ ଅଫିସର ବିଚାରା
if a
ଅସୁବିଧାରେ
bank
ପଡିବ।
employee, it will.
All right. Further, the learned judge, family court Berhampur shall do well to try and expeditiously dispose of the matter. Yes.
Item 26.
No instruction, your lordship.
No instruction. File a memo.
Hello, madam, I'm the opposite party.
Hello, he is withdrawing it. No instruction.
ठीक है,
Not
ठीक है,
pressed.
madam.
Not pressed.
Item 27.
What is the part? How is it?
This is a case for transfer of the suit from Khordha to Sambal. Both
For that to Sambalpur, yes.
Sambalpur. Khordha and Sambalpur both have jurisdiction.
No, my question to you on the last occasion was that this is a civil suit. You don't have to appear personally on every date. So why?
Your lordship, have my submission, then you
Yes,
can
yes.
take it here. Well, this is a partition suit. Claiming that it is an ancestral property. I have attached the cell leads. Cell leads. These are the property purchased by either dependent 1 or dependent number 2. So it cannot be ancestral property. Anyway, madam, that will be decided in suit. Our second thing, madam, both of them are living in Sambalpur. She is serving in Sambalpur. He has given a
Who is serving in Sambalpur?
lady is serving Sambalpur. He is a house in Sambalpur. Sambalpur.
No, lady means which lady?
Dependent opposite party number 1 to 3 living in opposite party number 1 is a service holder in a school, and opposite party number 2 are minor children, and they are reading in that school. Only of 2 is reading in that school.
Three is mine, much minor. Well, they're living together in Sambalpur. And all these cases he has given. He has denied in his counter, I am not reading in Sambalpur because of my harassment and all these things. Your Lordship, see, Annexure 2. Count. Page 9. My lord, page 9. No. Annexure counter na mo counter no. Tanko counter. One minute.
I'll go to the TRPC pending ଅଛି filed by the some bit of some this particular set my lord. The TRPC now that's a tragic case.
Page 33. Page 33. Your Lordship say he has stated she was working in 7/6/22 to 31/3/23. ମୁଁ କାମ କରୁଛି ତାପରେ ମୁଁ ବାଧ୍ୟ ହେଇକି ଇଏ କରିଦେଲି ରିଜାଇନ୍ କରିଦେଲି ଯୋଉଥିପାଇଁ ମୋ ପିଲାମାନେ ସେଠି ଆଉ ପଢି ପାରିଲେନି. This is the counter they have filed. My lord, your Lordship, see my rejoinder. Certificate issued by headmaster of the school. The Lordship, see. We got it in RTA and we applied to DO and DO written their letter to headmaster and headmaster. My Lordship, see. Subhasmita Bolyar Singh working as an assistant teacher in NIDA from 6/4/23 to 29/2/24. मतलब से कौन करूँगी एक माने ये मशहूर गोटे वर्ष पर गोटे मासा तंगो छुट्टी दी दूसरी तापर पुणे काम so she is working has given a wrong affidavit highly wrong affidavit he is working the period for which he has stated in affidavit his affidavit her affidavit wrong and subsequent to that it is a he is working there she is working there the poor likhich marriage say his daughter is studying also se katha bhi likhichi Subhasita Bolyar Singh's daughter Divyansa Samantara is student of Saraswati Shri Vidyaman Mandir. She is residing in class 2. Both are my lord. Second point third point I have appeared once in court. On that day I am humiliated and threatened to my life. Some gundas and all these people have come, but due to intervention of advocates in the court premises, this is subsided. Well, thereafter, I got threatening calls. I have stated in my paragraph 8 and 9. Your Lordship, the paragraph 8 and 9. Paragraph 8 and 9. That while petitioner as defendant number 2 and 3 appeared in court at Khurda on 16/3/23, They are harassed by OP number one, one's relation and their henchmen. They are abused in filthy language and threatened to their life and wanted for for attending the court. However, the intervention of lawyer and other persons present there have escaped from the shoes. Thereafter, both of them got threatening calls from unknown number, not to contest the case. The petitioner one received some threatening letter to abstain from the court at Khurda. The copy of one such letter is given in Annexure 6. To this 8 and 9, he has answered in rejoinder. Your Lordship, see the rejoinder. Rejoinder Annexure 7. Counter. Counter para 7, Your Lordship, see. Page 4 of the counter. After the death of deponent's husband, the deponent, in order to maintain himself and to maintain her two small worked in Saraswati Shishu Mandir, but due to harassment and atrocities made by the petitioner, the deponent forced to leave the school. My lord, that I have shown you, and I have seen that thereafter this is a wrong affidavit. Paragraph. Next, annexure page 13, paragraph 30, page 7. To these two paragraphs I have read just now, he says that the annexure 6 is that later, the petitioner was a false and fabricated, as the deponent has never written such letter, needs expertise opinion from the. But he has never denied the threatening letters and threatening calls and letters. That specifically about. Yes, no. And there is nothing in counter to control this. Apart from this, his old age, and I have given the medical reports regarding his ailment, and the gentleman was attended bed rest, and his wife is a neuro patient.
Still, this does not answer the query that I posed. It's a civil suit after all. The plaintiffs or defendants are not required to attend physically, except for giving evidence. So for that reason, why should the case suit be transferred?
But now this is my difficulty. I'm threatened to go there.
Yes.
And they have not controverted this.
What is the statement that the one property is Hon'Ble, my lord, in that is in settlement. They already para 5 they state the stored property schedule of the parent is already been identified away, must try to file a suit, my lord. Stated that in the statement. Again, my lord, the 4 cases are pending there, my lord. That 2 cases also initiated by the elder son, the Darshur of the present opposite party, and again, they also filed a complaint case before the Hon'Ble, my lord, only to harass me, my lord. And when I am filing the petition to transfer the case, they stated they already witnessed and examined, but till date he is not much charged, my lord. I also annexed that petition that he filed the amendment to annex that amend the complaint petition, my lord. And in one case, my lord, that his elder brother and his wife also have come to the Khurda and examined already Chigiri completed, my lord. That too his daughter, my lord, in one case also appeared and giving a statement that very good that the present dependent is staying at a Zonkia, my lord. But also, my lord, evidence that is in one case, my lord. So there are 4 cases pending there, my lord. In the away by the 3 more than 350 kilometers, and petition a widow lady and 2 small daughters, my lord. And there he has no protection there, my lord, because they already filed one complaint case against the petitioner, and elder brother also filed a complaint case before the petitioner in appeal party in the court also, my lord. That is subsequently registered the case, my lord.
My lord, may I answer to this, my lord? He has said that the 4 cases filed. To this petition number 1 and 2 cases. This is one case that who is subject matter of this case, and another case he has filed. She has filed section 9 under section 19 of the minor guardian maintenance act to get relief from the father-in-law, to give the maintenance from the father-in-law. That will be decided by their own merit or so.
That case is also pending, my lord, for transfer, my lord.
Just a minute, out there are other 2 cases, it is nothing to do with our case. This is elder brother. They say I opposite party number 4 filed this case against them. This is regarding a civil matters. And they have entered into that civil court. That says some criminal, he has filed a return to a year. There is nothing to do with us. Yeah, we are not going to give evidence there. Only these 2 cases. And he says that now once he stated that I don't want to say all these things, my lord. Why I filed a case in Sambalpur regarding? My lord, he is staying in Sambalpur. We are staying in Sambalpur. He has gone to our house and he has rebuked such a manner that it's a video clip. Video clip টা আছে যদি আমি চাহুনଥିଲି এটা দেখিବାକୁ
তাও দরকার
যদি আপনি I brought that. The manner in which he has gone there and harassed the old lady, it is old man and old lady. That is the difficulty, my lord. That's why case is filed.
All at all. Hearing concluded, judgment is out.
My lord, you also see that it is a question of life and death.
Yes.
That's why I have filed.
Yes.
And they have not denied this thing.
All at all. Yes, item 28.
May I please, your lordship. ছোট ছুয়াটা ছিল মিডিয়েশন কে বলে ଟିକେ ହେଇ যাই পারে কোন মিডিয়েশন পেইন্টিং
Your Lordship, I'm appearing for the petition.
All it.
Lordship, this is the petitioner is currently residing at Bhanjanagar. They filed a transfer application from Bhubaneswar to Bhanjanagar. And Your Lordship, the child is pursuing his studies in Bhanjanagar. We have also annexed the school's bona fide student certificate. It is at Annexure 2, my lord. It's very difficult for a helpless lady to come from Hon'Ble to Bhubaneswar just for that particular matter. This application has been filed. Also, in the case, they have also stated that their permanent address is that of Hon'Ble. So that is why it's a fit case, my lord. May kindly consider.
No, he's suggesting mediation.
My lord, the parties, as per my instructions, are not willing for mediation as of now. So the case may kindly be transferred to Hon'Ble.
Yes.
মানে ছোট ছুয়াটা আছে তো মিডিয়েশন কেবল মানলো হোয়াট হ্যাপেন
If he is not agreeable for mediation,
যাই পারে মানে ছোট ছুয়াটা আছে মানে
আমি কোনো ওয়ারেন্টি ইস্যু করিবা
ନାଇଁ ମ୍ୟାଡାମ ছোଟ ଛୁଆଟେ
ଛୋଟ ଛୁଆ ହଉ ବଡ ଛୁଆ ହଉ କିନ୍ତୁ
ମେଡିସିନ ହେଇଯିବ କେବଳ ସେ କେବଳ ତାଙ୍କର କୌଣସି ପରିସ୍ଥିତିରେ ମଧ୍ୟ ଶାଶୁ ସାଙ୍ଗେ ମୁଁ ରହିବିନି ଦିସ୍ ଇଜ ଦ ଓନ୍ଲି ପ୍ରୋବ୍ଲେମ ମ୍ୟାଡାମ ଛୋଟ ଛୁଆଟେ ବାଇଲଟ ଅଛି ଡାଇଭର୍ସଟା ହେଇଗଲେ କୋଉ ଛୋଟ ଛୁଆର ଭବିଷ୍ୟତ ପୁଣି ନଷ୍ଟ ମାନେ ଗୋଟେ ଖାଲି ମେଡିସିନକୁ ଯାଉ ଯଦି ମେଡିସିନ ଫେଲ ହେଲା ମାଇଲଟ ଟ୍ରାନ୍ସଫର ହବ ମୋର କିଛି ଅସୁବିଧା
If one party does not agree, why should I send it to mediation, Mr. Tripathi?
ଯାଉ ମାନେ ସ୍ୱାମୀ ମାନେ ବଡ ଅବସ୍ଥାରେ ଅଛନ୍ତି ମ୍ୟାଡାମ
ସେଟା ଜାଣିଛି ଆପଣ ଛିଡା ହେଇଛନ୍ତି ମାନେ ମୁଁ ଜାଣିଛି ସେ ଦାୟିତ୍ୱ ଆପଣ ନେଇଛନ୍ତି ସେଥିରେ କିଛି ଏଳା କରୁନାହାନ୍ତି ଆପଣ ସବୁ ଜାଣିଛନ୍ତି ପୃଥିବୀରେ ଯେତେ
କନସିଡର ହଉ ମ୍ୟାଡାମ ଟିକେ ଦୟା କର
That's all. My virtual mode and your presence will not be physical presence will not be insisted upon unless absolutely necessary. Always your advisement. Hello. Hello. Virtual mode personal necessity. That will be there. Oblige.
Item 29.
In the meantime, you carry on with your crusade.
ଲଢେଇ ଜାରି ରଖିଛି ଆଉ
29.
Item 29, going counsel is held up in another court. I am submitting on behalf of him.
Yes, no problem.
The transfer is now the petitioner wife have a breastfeeding child male, and she is
No, last time I had directed the parties to apply
Yes.
whether there is a possibility of
So
settlement.
on behalf of Mr. Bale, I am for the respondent, opposite party. So we are ready to go
For
for the
mediation.
mediation.
Yes, what do you say?
Last question.
What do you say? High Court Mediation Center? Only if you agree. If you don't agree, all right.
High
Mediation
Court, High Court mediation.
High Court Mediation Center. Date karo?
4th October.
4th October. The other order will be passed, जो formal order pass करा जाए for mediation. That order will be passed and this is matter.
Item 30.
Yeah, whether there was an interim order in that case? Yes. ଆପଣଙ୍କର ଆଜ୍ଞା interim order ଅଛି? Who is for the petitioner?
I am for the petitioner. The Vibhu Prasad Mahanti, the advocate, counsel.
आइए stay कर दिया. Yes, since it will go for mediation, let it be stayed. Yes.
Item 30.
Item 30.
30, if I may please, Your Lordship. Is the transfer petition filed by the wife, Your Lordship? For the transfer of.
I got to get the order be order number 4 be corrected accordingly. Yes.
For the transfer of CP number 137 of 2023 from the learned family judge, from the court of learned.
Status
family
of trial of the case in the court below. Yes.
The present petitioner has been set ex parte and the matter is being fixed for hearing, Your Lordship.
For hearing.
Okay.
Have you filed any application for setting aside the ex parte order?
As per my instruction, Your Lordship, the petitioner is not able to be present in the court, hence she is not able to file the same.
Then it becomes infructuous. Almost.
If I am permitted to appear before the court through VC also, Your Lordship.
No, why should I permit you? For that you need for that you need permission of the court itself. The court in which the matter is pending. You have to submit an application there through some local lawyer permitting you to appear through virtual mode. Why should this court grant you that liberty? Anyway, you have not filed any petition for setting aside the ex parte order.
I'll take instruction on that matter as well. I don't have any.
Then counsel for the petitioner submits that as per instructions received, the petitioner has been set ex parte in the court below. Stop. He is, however, unable to say whether any application for setting aside the ex parte order has been filed by the petitioner. Stop. List this matter on 6th September, on which date the counsel for petitioner shall specifically inform whether any application for setting aside the ex parte order has been filed in the court below or not. Yes.
Interim order may be continued.
Interim order to continue.
Much obliged.
Item 31.
May preservers. I am for the wife mallet, and I have filed a mallet 125 proceeding before the mallet judge family court for the in 2022 mallet, where I have given my evidence and evidence of for the husband was posted. He is not appearing or not cooperating, and in the year 2024 he has filed this under section 9 at mallet judge family court mallet Bhubaneswar mallet. So that's why I filed a mallet transfer petition. This was issued.
C.S.K. Bhajado, learned counsel for the petitioner is present. None appears for the opposite party on repeated calls. On the last occasion, several occasions, on the last occasion, there was no appearance from the side of the opposite party, despite sufficient service of notice on the last dates, that is 6/8/2024, 13/8/2024, and 28/2024. Therefore, without waiting any further, the transfer application is taken up for hearing. Allow कर दे.
Allowed at judge family court to mallet. Family court.
Allowed है जी. Allowed है.
Family court to Bhubaneswar to transfer.
Bhubaneswar कर दो.
To court that. Family court Bhubaneswar ले.
All right.
Item 32.
Hey, please, hey,
May I please your lordship?
The brief facts of the appeal is that, your lordship,
Why this has come in the supplementary?
your lordship, admission has been not been made.
For further order regarding status quo, no objection to the above has been filed. I hear for vacation of interim order, I hear for extension of interim order. This has not been admitted.
Not yet admitted. Initial stage and notices has been issued and order of status quo has been granted by this honorable court. And my learned senior friend appeared for all the respondents have already appeared.
Why has it not been admitted as yet? Oh, it had gone to the permanent and continuous Lok Adalat.
No, before that, the case has been not admitted. Only question of admission notice has been issued. The may I place, your lordship? Yes. It is a confirming judgment.
Yes.
The plaintiff, I am addressing plaintiff and defendant. Plaintiff filed a suit before.
Who are you?
I am the defendant number one. Plaintiff filed a suit before the learned trial court, praying three reliefs. One, to correct the record of right in his name. Two, to discharge the mortgage given by him to the defendant number one. Three mortgage deed. And permanent injunction and recovery of possessions. The learned trial court, the plaintiff's case is that it is the leasehold land of one K. Kamaraj trustee. In the year 1974, he executed a sale deed in favor of the present plaintiff, and present plaintiff is in possession. Plaintiff and defendant number two, who is his brother, is in possession of this short land. He needs of money. And he approached the defendant number one to help him, financially help him. On lieu of that, he executed three documents. That is exhibit B, C, D. Three documents, 3, 4, 5. Three documents has been executed. In the year 2000, he noticed to the defendant number one to take your money and give possession of the land. The defendant number one didn't turn up. Again, another notice has been issued, didn't turn up. Lastly, on 2003, he noticed to state officials under section 80 CPC as the property has been recorded in the name of the state. He issued notice and the suit has been filed in the year 2000.
Property has been recorded in the name of the state.
Yes.
So how could a mortgage deed be executed?
Yes, that is the crux, your lordship. The lease deed, K. Kamaraj Prusti, which he has taken 1954, the lease has been given to the K. Kamaraj Prusti. 3%, but it is fell into the share of the K. Kamaraj Prusti, who executed in the year 1974 a sale deed in favor of the plaintiff. By that time, the record of right has been recorded in the name of the state. And in the remarks columns, the Behind Dakhal Sutre has been reflected. On that basis, he tried to file a suit to correct the R1 in his name and recovery of possession from me and the discharge of the mortgage. The learned trial court part on my respectful submission, learned trial court didn't take into consideration section order 34 of the CPC. He straight away gone to decide the suit. Your lordship, kindly have a glance to the decree. In the suit, kindly have a glance to the decree first itself. I am drawing your lordship to the suit be same allowed in part against the defendant number one, and the counterclaim made by defendant number one is partly allowed on contest without cost. The plaintiff and defendant number two are directed to make repayment of 1,20,000 to the defendant number one within 2 months from the date of this order, and the defendant number one is directed to hand over the possession of suit property to the plaintiff and defendant number two within 2 months, failing which the plaintiff and defendant number two are to liberty to set the law into motions. This is the decree. Your lordship, kindly have a glance to the land trial court, frame as many as 13 issues.
So what happened? Tell me. Then you went in appeal.
I went in appeal.
Yes.
The plaintiff didn't challenge the.
So which part were you challenging?
I am challenging that the money which has been 1,20,000.
But that was a counterclaim.
Counterclaim without giving any interest.
Oh, so the interest part was challenged.
Yes.
And
furthermore, my respective submission, when he is not the title owner of the property, he cannot, the line trial court ought not have given the recovery position part, would not have allowed in his favor. That is my case.
So what happened in the first appellate court?
First appellate court is traversed beyond the pleadings. Section 150, he taken the, your lordship kindly have a first appellate court's order. He take 11, para 11. He taken the lease as a principal issue, and which has not been framed before the land trial court, and he decided on that basis only. Your lordship kindly pays 26 lease. The lease of 105 quote kar dele. And furthermore, the lessee, K. Kamaraj Prusti is not made a party to the suit. And the lease deed also not seen the light of the day, because it has not been filed before the land trial court also.
So the appeal was dismissed.
My appeal is dismissed. He didn't file his declaration of right title interest, he accepted the same. And furthermore, the ROR published in the year 1983, he filed the suit in the year 2007 to correct the ROR. And that limitation part also, not issue of limitation has not been framed before the land trial court also. And the land lower appellate court only mortgage deed katha koile, issue of limitation whether his suit is maintainable or not, that is also not there, your lordship. Most straight up and exhibit, jo exhibit ta mortgage deed tinta.
No, let us hear it out finally.
Yes, finally.
You have to admit it and finally hear it. Who is appealing, Mr. Mishra? You are appealing.
They have appealed for the 225. Those are the original defendants.
Mr. Maharana, you are appealing.
I'm one of the defendants.
So everybody has been, everybody is on board.
Yes, yes. State is the Tahsildar.
My case is that, my lord.
So let us hear it one day finally.
Reason being, my lord, my house has been used by the appellant. And it is admitted he has taken the mortgage. It is admitted that mortgage was on list. And both the courts has taken the mortgage deed as a collateral purpose because it was not registered under section 70. Second thing is that when he used my house as a lodge, gainfully employed, I am in outside. Let us the question your lordship has put a question to me. The land is belong to state. In fact, land is belongs to state. It was leased out to Canberra, that Reddy. Reddy has obtained the permission.
But there is a note of illegal possession in your name.
And the reason being, I claim right title interest. My friend also claim right title interest.
No, but you have not filed any appeal.
No,
I have not filed any appeal because I am satisfied with the decree passed by the learning court.
But your title was not declared.
That the court has negated my title.
Yes, you have not challenged it.
I have not challenged it.
You are satisfied with it.
The question is, my lord, whether a lessee, because I am stands on the foot of Reddy as a lessee under section 105, whether a lessee has a right to transfer or right to heritable, that has been sought by the learned court below as well as the learned appellate. In case of admission, I have no objection, but in case of status or stay, because he is enjoying the property without.
We'll hear it.
Execution case is at the
Mr. Mishra, we'll hear it within 10 days, 20 days. We'll hear it.
Like this, my lord, my friend has obtained the order and it's continued at the.
No, what obtained the order? This court has passed. This court has consciously passed an order. What do you say? Obtained the order?
No, I am not objecting the court. I am saying that my friend is taking it so liberally and adjourn the matter time.
No,
it will not be adjourned. No, it will not be adjourned. I'll admit it formally and fix a date for hearing on consent of the parties. That's all. All right.
One more submission, my learned senior.
No submission. Heard Sri J. Bhuya, learned counsel for the appellant. Peruse the impugned judgments, considering the submissions and the matter and the grounds released.
Deposit that amount.
No, this is not in his pleading.
My lord, if he will not deposit and the issue has been framed to that extent, you have not denied, you have admitted that I have taken.
Considering the grounds raised, the second appeal is admitted on the following substantial questions of law. We will admit it only on one.
your lordship seeks whether the plaintiff's possessory right is extinguished
2 and 6 कर दियो
in view of the proceedings
page
under
15
OPL Act.
page 15 2 and 6 करो है ना since the respondents have entered appearance pursuant to notice already issued prior to admission, no further notice needs to be issued to them. Copies of the appeal memo be served upon has also been served upon the counsel appealing for the respondents. ठीक है ना the LCR is necessary, isn't it?
LCR is there also.
LCR is
also. Yes.
Furthermore, the LCR is also available. The parties, learned counsel for the parties agree that the matter can be disposed of finally. Stop. In such view of the matter, list this appeal. Gote dino kod. Apan man 3 jon agree kari kod gote date. As early as possible, apan kod will finish it.
September.
Appellant कौन जो date
है? September 2.
September 2 था बने हमारा September. 2nd September. All right. 2nd September.
Week commencing.
In the week commencing 2nd September, it will come a little bit below in the weekly list, but weekly list will be exhausted in that week. All right.
One line may kindly be added that on the question. A joint decree, a single appeal is not maintained. That was urged also. And in the appeal also I have asked in the learning trial.
I think that can also be taken up.
Pardon?
You want it to, as a question of law?
In addition to that.
Yes, yes.
In addition to the 2 questions what my friend has.
All right, next I got a question add kar do. Whether a single appeal is maintainable against the findings?
Against the composite decree. There is 2 decree. One is counterclaim, other is
against the composite decree passed by the trial court in the suit as well as in the counterclaim.
In counterclaim. In appeal. Suit and counterclaim.
Only suit and counter. आप उठते खाली कोई भी जो ठीक है इशू substantial question number 4 टा भी ठीक है था कहीं ना सितरे पढ़ी कि when the mortgagee get position under a void mortgage, the mortgagor can recover position of the.
Sir, 2 recover है जो नहीं. 2 recover है जो.
How more stay of execution proceeding I am praying for.
That has already been stayed, Miller.
No.
Yes, you will also kindly see the last order.
Last status order.
Status you are in possession of my house.
That is.
And using it for a lodging purpose.
All right. Let the execution case be stayed.
He is using my property without giving a
2 तारीख आज्ञा 2 तारीख को ये हम सारी दबा अपने बस्ते क्यों
से स्टेटस कोटा था जिंते अच्छे से सिंता
इटंडा ठीक स्टे था उसे
और एग्जीक्यूशन
मैंने लॉरेंट ट्रायल इज प्रेसिंग हार्ड
interim order granted earlier shall continue till the next date. Yes.
Item 33.
33.
ଅଣତିରିଶ 7/2024 ଆସିଲା କି ସେଥିପାଇଁ
judgment. But it being adjourned time and again. And there is an interim order against me. As a result of which we are not in position to 2024 manner. In the meantime, 6 weeks my lord.
No, 4 weeks. Yes.
Difficulties in my lord. ପିଲାମାନେ ରହୁଛନ୍ତି ବାହାରେ.
No, 4 weeks, sir. End of the matter.
36.
Item 36.
Your Lordship, in item 36, I am praying for an adjournment on behalf of Mr. Sarthak Naik, Your Lordship. On the last occasion, we were supposed to get instructions in the IA, Your Lordship.
Yes.
Due to some medical emergency, Mr. Naik is unable to appear.
Yes, he is asking for interim bail for cardiac surgery.
Yes, Your Lordship. Due to a medical emergency, Mr. Sarthak Naik is unable to appear today before Your Lordship.
Next week, next week. Therefore, adjournment is made on behalf of Sri Sarthak Naik, learned counsel for the CBI, on the ground of his illness.
Yes.
On the ground of his illness.
Father's illness.
On the ground of his father's illness. His father's illness. What?
Mr. Dharan Naik, senior counselor, is admitted in care hospital.
Oh, I didn't know
Yes,
that.
sir.
Yes, I didn't know that.
In the night, he was shifted to
Last night?
Thereafter.
Last night?
Yes.
yesterday evening.
Oh, I didn't know that. Okay. Tell this matter next week.
My lord, item 35, my lord. Urgent copy is granted today, my lord.
All right. Urgent copy 35. Urgent copy in court of the day. Urgent copy in course of the day.
My lord.
I'm going to examine the question. You better watch it.
Item 37.
Yes. 37.
Yes, Lordship. I am in the PLFL 431 of 2024. Jahid Khan. Lordship has kept matter pending for the last 4 months.
Item 1, we are appearing, my lords. First item.
Yes.
My lords, here.
You are ready with the case diary? Okay, there is that. All right.
My lords, the FIR
Some of the
indicates.
co-accused person, your lordship has rejected.
Yes, my lords. Not yet. Your lordships will kindly see the FIR at running page 8.
Yes.
My lord, 2 persons entered in a bedroom. Dacoity is the allegation and stolen our mobile phones, ornaments, and money around 3 lakhs. Right, my lords?
Yes.
This is the FIR. Now, no TI parade is held, my lords, conducted. Plus, the police goes on to say, in course of investigation, total cash of 1 crore 68 lakhs, stolen gold ornaments recovered from the possession of above named accused persons. My lords, he himself alleges 3 lakhs. Now, where do they get this 1 crore 68 lakhs 50,000? This is in course of investigation. Your lordships may kindly see the charge sheet at running page 12.
Running page 12 is not the charge sheet.
Charge sheet of 12. Running page 12.
Where is the charge sheet?
Again. Annexure. Annexure Haney. दिया है तला सर आपको हियरिंग रे अवश्य मुन नथली समान
charge sheet दिया जी. Oh, this is a EA matter, so this may not be available. The hard copy is not available. Charge sheet achi.
It does sir.
You know, he says that in course of investigation, all total cash of rupees 1 crore 68 lakh 50,000 stolen gold is recovered from their possession.
Sir, from the previous paragraph, your lordship.
Yes.
During course of investigation, the complainant and other witnesses were examined. The spot was visited. Investigation disclosed that on 2/8/23 in between 7:30 to 8 p.m. when complainant along with his son both were sitting on his dining sofa, suddenly 6 persons entered into the house with guns and knives. They represented themselves as CBI staff and pointed the gun towards them and locked them at father and son inside the kitchen. The accused persons closed their mouth on sellotapes and tied their hands in towels. Out of them, 3 persons entered into his bedroom and stole gold ornaments, mobile phones, and cash of rupees 3 lakhs from the locker of the Godrej Almirah, and cash of rupees about 2 crores kept by Rajendra Kumar Nanda, brother-in-law, in his house in 2 numbers of attache. Now, where this is not reflected in the FIR. Nothing is there in so far as who is his brother-in-law, why has he kept 2 crores in this in an attache in their house. Nothing is reflected, my lords. Then they say that in course of investigation, we recovered 1 crore 68 lakhs. Now, no TI parade has been conducted. And my lords, your lordships had also wanted to know about the criminal antecedents. We are not, because he is in the jail, we were not able to, my lord, the state can.
Last item, no
Investigation
criminal.
is still open, my lord. And from the confessional statement of the co-accused persons, they have been arrested, my lord. And from
all the accused persons, different amount has been seized. From this present petitioner, 28 lakhs has been seized from him. And investigation is open, so.
Investigation concluded.
No, not concluded. Final charge sheet has
178.3. 178.3.
Yes, my lords.
And
This present petitioner,
What accused person is still absconded?
from the local inquiry on that day, this present petitioner's vehicle has been there, my lord. It
Yes,
has
sir,
been
it's a commercial
ascertained.
vehicle, it's a taxi.
Yes, it has been ascertained from the RC book, from the RTO that.
It's a taxi. And my lord, he is in custody since 27/8/23.
I have rejected one of your.
During investigation, my lord. That
During
was rejected
investigation.
During investigation. Now, in the meantime, about 1 year in custody.
1 year, my lord.
And
27/8.
Still it is
Ajmer
open,
Ali
my
and
lord.
Raja.
Yes.
Ajmer Ali.
That was rejected during investigation.
Sub item 1 to be rejected.
No, emanaka kahe rejected.
What was recovered from the possession of this
28 lakhs, my lord.
28 lakhs.
Yes.
And from the other petitioners?
From the other petitioner, Sanatan Naik, 50 lakhs, one country-made pistol, and he has 8 criminal antecedents of similar nature.
Yes.
And from next, my lord, Jahir Khan, 10 lakhs has been seized, my lord. And next, that Sanjay Malik, 20 lakhs and some gold ornaments, 1 gold necklace, 2 earrings, 4 finger rings, that has been seized, my lord.
So that is one part. That
Yes.
shows that they are somehow criminally oriented.
Yes, my lord.
But how do we link them with the present case? What is the link? Apart from the co-accused statement. And who is the co-accused? On whose statement they have been implicated?
For the first item, we answer, my lord, Hemanta Kumar Dhir, basing on the statement of Hemanta Kumar Dhir, other person has been implicated in this case.
Now, how was Hemanta Kumar Dhir implicated?
His vehicle was recovered during,
And which is a commercial vehicle.
from the forwarding report, it shows.
A query was made by the investigating agency from the RTO and the vehicle in question that's done in the name of Hemanta Kumar
Dhir.
That is why he was implicated in this case.
And basing upon Hemant Dhir's confession, other accused person.
Other person has been.
And as the state also says, my lords, Dhir has no criminal antecedents.
So, but he has confessed to the crime.
Yes, ma'am.
Isn't it?
Yes, ma'am. And huge amounts were recovered from different persons, gun and gold ornaments, everything.
How do you explain this recovery?
Recovery 28 lakhs, my lords. What 28 lakhs? Because the initial FIR is 3 lakhs. If 2 crore 3 lakhs has gone, they would have written 2 crore 3 lakhs.
No, but how could you possess 28 lakhs?
No identification of the money, my lord. That denomination, it may be that the cash was recovered from their house.
No, difficult case. Yeah, difficult case.
Cash has no link with the case, my lord.
No.
Lords, 28 lakhs. Where
जाओ
does
आप किस दिन जाओ देखिए जाओ किस
हाँ,
दिन
किसी दिन
जाओ हम आज से 2 मास जाओ देखिए
ठीक है.
But let's see. Wait.
Yes.
But my footing is different.
What?
I am an 18 years old boy. I was the driver of an accused.
No. All of you are standing on the same footing.
I don't have any criminal antecedents.
No, sir. If you want, I can take up your case again independently, but I don't think I will release this matter 1 week after. Hala, 1 week after, जाओ से मासा को परे mention करिए देखिए. Today somehow I am not inclined.
Sir, ठीक है. Sir, what a date fixed for August and September. Sorry, August and September.
October, sir.
October, sir.
Let's this matter in
25th October.
25th October. In the meantime, you find out. In the meantime, the State Council shall apprise the court as regards the result of further investigation, which is said to be going on. So, yes, after submission of charge sheet. Yes. ये देखते हैं बस लिस्ट को देखिए पड़ती है कैलेंडर को देखिए
October छुट्टी पर हाँ ठीक
item 39
Item 38.
38 I'm sorry.
Yes, even item 38, I'm praying for an adjournment.
Is this matter 1 week after?
Yes. Item 39.
Extension of interim bail. Lordship, last occasion, 1 month was granted for.
Considering the grounds, interim bail granted by the order so and so is extended by for the period of 1 month. Yes.
41 also same, another.
Between same.
Aye.
Same. 41 same. Yes.
Item 40.
My pleasure, Lordship. 49 kg, 270 grams of ganja was seized from the possession of the petitioner. And Lordship
The sole accused, my lord, and
Lordship already rejected in the month of November 2023. The Lordship kindly see for a moment paragraph 7 of page 5. That is the plea only that one Prashant Dev, who was the owner of the car, had made consignment of his vehicle at Vishal Cargo Packers and Movers for shifting of his vehicle from Mumbai to West Bengal. And the petitioner was the driver. And the way one person asked for lift, who carried 2 bags. And on the way checking, she fled away from the car, and the petitioner was, since the driver has got red and the back of the husband.
Is it Chatoi? This is matter 1 week after.
Item 42.
Any date, ma'am, fix any date.
1 week after.
May it please your lordship. Your lordship was pleased to have this matter, my lord. And your lordship was pleased to allow the interim bail application of the present petitioner for some time. And again, my lord, I have filed this, and in right time, this present petitioner surrendered before the London court below without any fail. And he has no criminal antecedent. What happened, my lord? I have filed this application that so many important witnesses, my lord, they have already been examined.
Deposition order file itla. After likhaichi order.
I have handed over the copy of
yes, 17 let the same be kept on record.
And one sole problem is
same be kept on record will likhala.
Sole problem is, my lord, the court below, that court is not functioning. And my lord, I am in custody. So for that reason, my lord,
out of 38 witnesses, 17 witnesses has been examined.
Examined, my lord.
PW 15, 16 and 17. They have fully supported the prosecution case, my lord. And within 1 year of the marriage.
So I grant him further interim bail for some time. I grant him, keeping this pending, I'll grant him interim bail again. File an IE.
My lord.
File an IE, we'll take it up next week.
Court is not functioning, that lord.
Sir, file an IE.
I have not filed one. And dispose of this, my lord.
No disposal.
Again, my lord, I will file.
I'll keep it pending. I'll call it next week. In the meantime, you file an IE.
Yes, sir.
Well,
yes.
Let's just matter next week.
43.
May I please your lordship, my lord. Custody 21/8/2021.
You are practicing in this court, Mr. Panda. We are unable to see you. That is why. Yes.
Custody 21/8/2021. Out of 19 witnesses, only 2 witnesses examined.
I will reject it.
That is annexure 3 running page Miller 20.
Lordship granted.
71 ବର୍ଷର ବୁଢା ମିଲର
ବ୍ରାଉନ ସୁଗର କୁହନ୍ତୁନି
ବିଲେ ଗ୍ରାଉଣ୍ଡରେ 3 ବର୍ଷ ହେଲାଣି
ବ୍ରାଉନ ସୁଗର ହବନି
ଲୁକ୍ ଇନଟୁ ଦି ରନିଂ ପେଜ 22 ମିଲର ଆଉଟ ଅଫ
28 କେଜି ହେଲେ ବି ହଉଛି କିନ୍ତୁ ବ୍ରାଉନ ସୁଗର ହବନି ବ୍ରାଉନ ସୁଗର ନୋ ଲିନିଏନ୍ସି ଆଟ ଅଲ୍
Lordship granted interim bail for 2 months.
ଯାହା
17 1 years ବୁଢା ଲୋକ ମିଲର ସାକ୍ଷୀ ମୋଟେ ଆସୁନାହିଁ ଆଇ ପ୍ରେଇଂ 2 months ମିଲର ଫର୍ଦର ଇଣ୍ଟରିମ୍
file I will keep it pending and grant. Let's just matter next week as well.
Item 44.
In the meantime, whatever. In the meantime, you file. Item 44, yes.
Before, my lord, I have filed a IA that for order for parity, my lord, in the first ABLAPL dispose of bail application 453 of 2024. Because in that
IA you have filed, in that case you have filed an IA.
Yes, ma'am.
That has not come.
That has come with a case.
With a case, yes.
With a case.
With us.
Subsequently, जो हम file करते that will be
will be withdrawn.
Yes, my lord, and that parity
So
order
here,
not there, so I only.
Therefore, modification is allowed only to the extent of adding the following sentence at the end of paragraph 6 of order dated 22/2/2024.
Some time maybe.
What are the courts below?
shall consider applying the principle of parity to the petitioner, since it is submitted that some co-accused persons have in the meantime been released on bail. Stop. 2 weeks further time is allowed to the petitioner to surrender. Faster, permitted to withdraw.
Item 45.
45 permitted to withdraw, Lordship. Permitted to withdraw.
Item 46.
Here is also Miller, old man 17 years Miller, an allegation that Miller, contraband Miller kept in a government quarter. And the
Kete kg? Ganji? Is it Ganji?
Again.
Kete kg?
92 kg Miller. ସେ ଘରଟା ମୋର ନୁହଁ ସରକାରୀ କ୍ୱାର୍ଟରରେ ଥିଲା ମୋର 70 ବର୍ଷର ବୁଢା ଲୋକ ଆଜ୍ଞା ମତେ ଖୋଜୁଛନ୍ତି ଆଜ୍ଞା ଚାଲି ବୁଲି ବି ପାରୁନି
Case diary is not available and dismissed for default hitla restoration file karta again they have filed earlier it has been
dismissed for default and it has been restored.
Not restored, again he has filed fresh without filing restoration.
ହଜିରଙ୍କ ପାଖରେ ତ ଆସିବ disposal.
You can seek restoration of that order. In the meantime, we can ask for the case diary.
Step file କରିଦେଇକି
Habani. You file a petition for restoration. I'll allow it. In the meantime, we'll just call for the case diary so that the case diary can be utilized in the other case also.
Yes,
all right.
Yes.
This is just 51 kgs, no?
92.
92 kgs, no problem. Local man, no, so that's not an issue. Give it to Roland customer. But anticipatory bit, that's fine. Case diary up to date. I'll protect you. So why up to date case diary be obtained? Release this matter on 20th September with ABL appeal number 9917 of 2023. Till such time, no course of action shall be taken against the petitioner.
Item 47.
Well, an offense under section 20A of NDPS Act and 27(1) of Odisha Forest Act, my lord. In the meantime, my lord, co-accused persons has already been released on anticipatory bail by this honorable court, my lord. Allegation is the cultivation of cannabis plant in a forest land, my lord. Not named in a FIR, my lord. Subsequently, charge sheet has been submitted against the petitioners and others.
Earlier approached, my lord. Earlier approached 922 by 19. It has been disposed of.
Due to COVID-19.
In the same day, 4 weeks time was given. Same day, parity, release of co-accused, everything is there.
Due to COVID-19, he could not be able to surrender, my lord.
So why don't you file a...
Has been transferred to...
No. Why don't you file a petition for modification in that case? I will... That order will be there. I will grant you further time. So you have got whatever relief you wanted, you have already got in the previous order. For some reason, you did not surrender. All right.
My lord, co-accused release on anticipatory. Not named in FIR, my lord.
Sir, you filed an application for modification in ABL appeal number 922 of 2019. That in that case, I will say that parity will be maintained and so also. And I will grant you time to again surrender before the court below. New case taken, the order already patched. You have not complied with the order of this court.
Thereafter, the case has been transferred to Pontaman.
Maybe. Doesn't matter. It is still a judicial order. To file a petition for modification. Release this matter next week. In the meantime, you file a petition for modification in that case. Yes.
Item 48.
What is this matter? My lord, may it please your lordship. My lord, on 20th of August, your lordship's directed listing on IA number 8165/2024, filed by the respondent. Yes. My lord. Your lordship may kindly consider, my lord. Yes. The 184. Suit land, that is the only passage for the respondent cum plaintiff. 184 ta? नहीं तो 184 का नहीं 816 of 2024 अच्छी आगे 816 you filed 816 my lord all yes my lord. What has happened? The matter suit has been admitted, the appeal has been admitted your lord. Yes my lord, the respondent is the plaintiff. The suit land is 74 years old, my lord. The suit land is the only passage for him to approach the main road. Now there are two concurrent findings in my favor. that the suit land belongs to me, it is used by me as road, and they have forcibly constructed Pokka house over the suit land. First thatched house, thereafter objected, they forcibly constructed, and the honorable courts have directed to remove the construction.
Yes.
The Lordship may kindly see under these backgrounds when they have filed a second appeal. Then also, my lord, I have filed a caveat. My lord may kindly consider paragraph 3 of IA number 816/2020.
Paragraph 3.
My lord.
Yes.
I am reading, my lord. The respondent has filed a caveat petition in this case, bearing caveat number 29/2024. It is filed on 13/5/2024. The applicants have received the caveat notice on 17/5/2024. But on the date of hearing, that is 5/7/2024, the applicants didn't disclose that caveat notice have been received by all of them, nor even they have served a copy of the RSA. Your Lordship may kindly consider that as per 148 days CPC also, they are duty bound to give a copy to the caveat. I have given all the postal receipts. My respectful submission that in any case, even if the caveat has not been brought, but it is the duty of the appellants to at least inform the honorable court that the caveat has been filed and they have received the notice. Now, your lordship has passed an order, and we have also received notice in the meantime. The difficulty, my lord, may consider that living now in this rainy season, my lord, in knee depth water, I am going in a narrow passage to approach the main road. I have no other passage, man. And the honorable court, the learned lower courts have been pleased to give a finding that the suit plot since 1928-29 correct settlement, from that period it belongs to me, and the defendant's plea that 1944 the ex-landlord's pata in my favor is forged one. 1982 MS record, thereafter tenancy letters prepared in my favor, forged one. 1982 MSROR prepared in my favor, forged one. This plea of only that I have forged everything starting from 1928 to it is not at all believable. And they have purchased land from me also, which is situated in nearby area. They have their own house although situated in the nearby area. Now, when 1987, they have purchased land from me in that same area. They are very well aware that MSROR was also.
Now, what do you want? What do you want in this IA?
My prayer is that, your lordship, may kindly consider that I may be given the passage to approach the man.
Yes, that ingress and egress can be, you cannot stop him.
That is, there is a.
That to that extent, the model will be modified only to the extent of saying that you cannot obstruct the ingress and outgress of the respondent or plaintiff, whatever, through the suit passage or suit land till disposal of the appeal. That's all. Correct?
সেটা আগে পুরা কনস্ট্রাকশনটা করতে চান
তাহলে ଯିବେ କେମିତି ଆପଣ କୋଉଠି ଘରଟା ଭଙ୍ଗା ହେଇପାରିବ ଏଇନା ସେ ଆପିଲ ସରିଲା ପରେ ଯାହା ହବ ନା ଯଦି ଇନଗ୍ରେସ ଆଣ୍ଡ ଇଗ୍ରେସ ସାଙ୍ଗେ ସାଙ୍ଗେ କରିଦେବା ୟୁ ଆର୍ ପରମିଟେଡ୍ ଟୁ ଦେ କ୍ୟାନଟ୍ ଅବଷ୍ଟ୍ରକ୍ଟ ୟୁ ବଟ୍
ମୋର ଟିକେ ଆଜ୍ଞା ଖାଲି ଗୋଟେ ସ୍ମଲ୍ ପ୍ରେୟାର ବିଫୋର ୟୋର ଲର୍ଡସିପ୍
ୟେସ୍
ଜଣେଣ୍ଟ ଲୋୟର କୋର୍ଟଙ୍କ ଖାଲି ଫାଇନାଲ ଅର୍ଡରଟା ଆଜ୍ଞା ଟିକେ ପଡିବ
ନାଇଁ ବର୍ତ୍ତମାନ କଣ ଅର୍ଡର ଦିଆଯାଇପାରିବ ଆପଣ କୁହନ୍ତୁ ହ୍ୱାଟ ଅର୍ଡର ଡୁ ୟୁ ୱାଣ୍ଟ ନାଉ ୟୁର ପ୍ରେୟର ଇଜ ଦ୍ୟାଟ୍ to vacate the interim order or may modify the interim order. Vacation of interim order means demolition of the structure.
Execution is going on.
Demolition of the structure. Now, when the appeal is pending, structure will be demolished.
May I only pray one thing, man?
Yes.
If the lordship will consider that both the fact-finding courts have given my favor.
Whatever.
My lord.
It has been admitted.
They are not remediless. If your lordship will permit the execution, in case they succeed, 144 CPC permits
restitution
on the same
no, that
then your lordship may be kind enough to consider looking at my age.
No, yes, what do you want? Tell me.
Mate agya seti gote safe passage se mane provide karan.
Ingress and outgress you cannot stop him. That I am willing to pass right now. Right now I am willing to pass that order. Well,
and may I make a small prayer?
Yes.
Because I am 74 years old. May I pray that your lordship may kindly hear this matter if your lordship would be kind enough to.
Yes. LCR ଆସିଲାଣି ଆସିନି ରିମାଇଣ୍ଡ କରନ୍ତୁ ରିମାଇଣ୍ଡ ଦି କୋର୍ଟ ବିଲୋ ନାଇଁ ଆମେ ତ ଏବେ କରାଇଥିଲେ ଇଏ ପାଇଁ ମେନସନ ଆସିଛି ନା କେବେ ଆସିଛି ଏଟା ଆଡମିଟ କେବେ ହେଲା କଲ୍ ଫର ଦି LCR ହେଇଛି ଏଟା 5/7 କୋଉଠୁ ଆସିବ LCR
ଭଦ୍ରକ ସିଭିଲ ଜଜ୍ ଜୁନିୟର ଡିଭିଜନ ଭଦ୍ରକ
remind the court below to transmit the LCR as early as possible. Yeah. Release the appeal for final hearing on what a date could be October, right?
In the week commencing 21st October.
In the week commencing 21st October. IA 861, 816. This is an application filed by the plaintiff respondent for vacation of the interim order, vacation/modification of the interim order dated 5/7/2024, passed by this court in IA number 661 of 2020. Stop. It is submitted that the petitioner, the plaintiff respondent, is an old man, aged about 74 years, and has been using the suit land as a passage to approach the main road. Stop. It is further submitted that both the courts below have concurrently declared the title of the plaintiff over the suit land and directed the defendants to remove the unauthorized construction made thereon. Stop. The learned counsel appearing for, it is submitted on behalf of the defendant appellants that the appeal having been admitted, the interim order passed by this court should continue till disposal of the same. Stop. After hearing both parties and on consideration of the rival contentions, this court is of the view that even though the appeal has been admitted and an interim order has been passed in favor of the defendant appellants, yet the plaintiff respondent cannot be denied access or passage over the suit land in order to approach the main road. So, the interim order dated 5/7/2024, passed in IA number 661 of 2024, is hereby modified. Modified only to the extent of adding the following sentence after the first sentence. Stop. However, the defendants shall not obstruct the ingress and outgress of the plaintiff respondent over the suit land or prevent his access to the main road thereby. Yes.
May I make a small prayer, my lord?
Yes.
Lords, may kindly call it as a part matter on that date.
24 matter? You are saying 2003 matter pending hai. What pressure it is having on the court, you can imagine. Sorry. Password kitna? Tinta lag do. No, lag do. Password
Item number 14.
None appears next week.
Password item number 16.
16 को final hearing.
Madam.
Happen nothing se to ago ikna. Aro week rasu. Mr. Bera, it will come next week.
Your Lordship only, Your Lordship kindly see last order. Your Lordship directed to produce the notification. My Lord.
What notification?
Senior, and file and today serve an affidavit.
Oh, that ECC.
ECC.
An
affidavit has been filed, but I don't find it sufficient. It has to be further.
No,
Your Lordship directed to
notifications.
40 EC center, Ektali as well as Mangad.
The relevant document regarding establishment of ECC of Mangad School under Revenue Village Ektali.
द्वितीय बैठक ईसीसी कमिटी फॉर्मेशन उच्च शिक्षा व्यवस्था को कार्यकारी करने उद्देश्य प्रत्येक उच्च प्राथमिक विद्यालय अधीन 2टी ईसीसी सेंटर खोली शिक्षादान करा जिवो दिस डिसीजन वाज टेकन
That is what my lord I am submitting on the last occasion when so far these ECC centers have to be there, my lord. These are to be under the school master education. And the Anganwadi centers, my lord, the people from the WNCD department, my lord, they do not have any access to the establishment of the ECC. So after receiving your lordship's order, they contacted the concerned headmasters, and the headmasters on such, my lord, they found that this is the only document. What
this is the resolution.
Yes.
We'll keep it on
supporting letter, but
whatever worth, we'll keep it on record.
So your lordship wanted that this would be filed in shape of an affidavit.
Yes, yes. That is why I said.
Yes.
Yes. This affidavit you are filing today?
Yes. It is already filed.
No.
No.
Additional affidavit also. As Director and State Council files additional affidavit enclosing copy of resolution relating to establishment of ECC center at Mangad village. The same be kept on record. Let a copy thereof be served upon land council with the petitioner. Let's this matter, we'll take it up next week.
6 September.
On 6th September. How?
I don't know, 20. No, I don't 20, my lord. In this case, my lord, in fact, to add one, Sumita Badoville as a party. She is not a necessary party as because page 55 will also you kindly have a glance. Page 55, Annex 8.
Annex 8.
Again. By practicing fraud, she had submitted the first document, mark sheet, all these things, and selected as Anganwadi worker for Handipota Anganwadi Center, my lord. Thereafter, I filed case and the sub-collector set aside her appointment. Now, next, she is not challenging the same. Thereafter, the order was passed to verify my documents. Documents were verified, but the sub-collector transferred, new sub-collector came and he passed the order. No, fresh advertisement. Challenging the same, I have come. And
but where is the schedule?
It is the Sumita. Yes.
नहीं नेक्स्ट वीक आसु करियो
आगे
बोल के फाइल करन तो
आगे मु ये करेक्शन करी फाइल कर
अरे बिल्कुल शेड्यूल ही नहीं
नहीं खाली पार्टी नाटा लिखि दे
प्लीज दिस मैटर नेक्स्ट वीक एज पर ऑल
मु एटा आज फाइल कर दे
आज फाइल कर दूं तो फिर काम नहीं हां तो ठीक तो
was the subject matter of challenge, the recital of which says that he has received the consideration meaning. And I brought your lordship notice to section 91 and 92 of the Evidence Act. So that a person who has executed the sale deed, they are the father of the plaintiffs. So he has not challenged. He has not been examined as a witness. The son says that he has not received consideration. The recital says that he has received it. And evidence also that he received, B6 received and gave it to B5. Therefore, when the sale deed remains valid, title passes, and the defendants are the rightful owner of the property who have purchased on payment of good money.
Madam, my respectful submission is, madam, once there is a partition, even after the partition, it remains the status of ancestral property matter. So plaintiffs had every right, there is a right to file the suit. On last occasion, I relied on one judgment of Hon'Ble Apex Court reported in 2018, volume 7 SEC, page number 646. May I read it, madam? In paragraph number 12, short paragraph, I may be calling. It is settled that the property inherited by a male Hindu from his father's father or father's father is an ancestral property. The essential feature of ancestral property, according to Mithakshara law, is that one son, grandson, and great grandson of the person who inherits it acquire an interest and the rights attached to such property at the moment of their birth. The share which a co-partner obtains on partition of ancestral property is ancestral property as regards his male issues. After partition, the property in hands of the son will continue to be ancestral property, and the natural or adopted son.
Mr. Kora,
My lord.
you have to first contend with the contention that you ଲେଖା ହେଲା ଜର ସମାନ ବାବଦକୁ ଏଥି ପୂର୍ବେ ବୁଝିନେଲି ସମସ୍ତ
I will answer to your lordship's query, madam.
ସେତିକି କହିଲେ ହବ.
That the judgment
title passes
that right.
And when the vendor himself,
no,
what is there? So contention, I'm just saying it so that it will be easier for you to answer. Now, the vendor himself does not come forward to challenge. It is the vendor's son who comes forward and says and tries to adduce evidence, which is well contrary to the clear and unambiguous recitals in the CLD.
I would humbly differ, Maharaj. You lordship may kindly see that recital of that document.
I had seen it, Exhibit A.
Two things are there. Maharaj, we are not barred from taking the help of section 92 because section 92 proviso 1 saves me. Your lordship, I may be permitted to read out that provision.
Yes.
That proviso 1.
Yes, please.
That judgment relied by the appellants, it rather helps me, my lord. It says, exclusion of evidence of oral agreement. When the terms of any such contract, grant, or other disposition of property or any matter required by law to be reduced to be the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, varying, adding to, or subtracting from its terms. Then comes proviso 1. Any fact may be proved which would invalidate any document. It is the first condition. Or which would entitle any person to any decree or order relating to thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in any contradicting party. Then, my lord, comes want of failure of consideration. I am there, my lord. If there is a question whether the consideration amount had passed to the defendant number 5 or not, in that circumstance, my lord, oral evidence is allowed.
What is the meaning of then ଜର ସମାନ ବାବଦକୁ ଏଥି ପୂର୍ବେ ବୁଝିନେଇ
ସେଇଟା ମୁଁ ଆଜ୍ଞା
ସମସ୍ତ ଟଙ୍କା
ଆଜ୍ଞା
ତାର plain simple meaning ହେଲା ୟା ଯାହା ବୁଝିଲୁ ଆମେ
ତାକୁ ନେଇକି ବି oral evidence ସାଙ୍ଗେ oral evidence ରେ defendant number D, defendant number 6D, the son of defendant number 6, he has admitted several times that money was received by defendant number 6, not defendant number 5. Defendant number 6, he paid that amount to the bank, State Bank of India for the loan that he had taken. It is there, my lord. Now the bare reading, if your lordship allows me, that imbue, the cell deed itself contains, my lord, imbue ବିକ୍ରେତାଙ୍କର ଦେଣ ପରିଶୋଧ ନିମନ୍ତେ ଟଙ୍କାର ବିଶେଷ ଦରକାର ହେବାରୁ ଆମ୍ଭେ ଅନ୍ୟତ୍ର ଉପାୟରେ ଟଙ୍କା ଯୋଗାଡ଼ କରି ନ ପାରିବାରୁ ଆମ୍ଭ ନାମିତ ଥିବା ତଫସିଲ ମୁତାବକ 80 ଡେସିମିଲ ଜମିକୁ ଶୀର୍ଷୋକ୍ତ ମୂଲ୍ୟରେ 24,000 ଟଙ୍କା ଜର୍ସମନରେ ବିକ୍ରୟ କରିବା ପାଇଁ କଥା ସ୍ଥିର କରି ଜର୍ସମନ ବାବଦକୁ ସମସ୍ତ ଟଙ୍କା ଏଥି ହୁଏ। ମାନେ ସେ ନିଜେ ଏଇଟା ବିକିଛି। He himself had transferred this property if there is any transfer, madam, not for the benefit of entire estate of the joint family, madam. That is my first hold of submission. Second is, my lord, that it is not a case that I cannot take the help of oral evidence. If your lordship permits me, I will cite two judgments. My lord, may kindly come to paragraph number 6. May I? Yes. On the basis of the aforesaid decision, it can be said that it is almost settled that the question whether title passes on mere execution and registration of the deed or only on payment of consideration depends upon the intention of the parties to be gathered from the deed. It has also been held that though the sale deed may recite that the consideration has been paid, but there is nothing to prevent the parties from adducing evidence to show that the recital is untrue and that in fact the consideration was not paid. This will not be barred by section 92 of the Indian Evidence Act.
Almost like a, you may say that he was coerced into writing, or there was a fraud, or there was misrepresentation. There is nothing, sir, no such pleading here. Is there any such pleading here?
But I can help that. I can take help of the oral evidence. The cross.
Not in all cases. Not in all cases. Not in these cases. Not as a matter of course.
But in this case, when the plaintiff's dispute and the admission made, not only in the oral evidence, but the paragraph 6 of the plaint, your lordship knows that the admission made that is relevant under section 58 and what have been admitted in the plaint, it requires no proof further. But your lordship kindly see the paragraph 6 of the plaint, written statement filed by the defendant number 1 to 4 and 6. Paragraph 6. The consideration was paid to the defendant number 6 in present of defendant number 5.
Paragraph kite?
Paragraph 6.
Of written statement of?
The written statement of
1 to 4.
1 to 4 and 6.
Yes.
6 died during course of trial.
No, but paragraph
page 6, paragraph 6.
Of the written statement?
Again.
TS number 3493.
Again.
Written statement on behalf of defendant numbers 1 to 4 and 6.
Again.
Para 6 begins that the averment made in paragraph 1 and 2 of the plaint is true except
page 6, page 6.
Yes.
I'm sorry, my lord. Page 6. That starts with legal advice given by their advocate.
Paragraph 6.
I'm sorry, my lord. Page 6. Legal advice given by their advocate. Under such circumstances, these defendants agreed to get the sale deed dated 16/2/93 executed in their favor by defendant number 5, and the sale deed was duly attested by defendant number 6. The consideration was paid to defendant number 6 in presence of defendant number 5 and one Prabhat Kumar Upadhyaya, the son of defendant number 6. So they have admitted in this in their written statement that the consideration amount was paid to defendant number 6, not to defendant number 5.
Yes.
In addition to that, they have admitted the son of defendant number 6. He has admitted in his oral evidence in the course of cross-examination that the consideration amount was paid to my father. He took that money to the State Bank of India and paid. In these circumstances, my lord, oral evidence is allowed. I come under the proviso 1 of section 92.
Yes.
My lord. And more particularly, this property is an ancestral property. Defendant number 5 alone had no right over the property to alone alienate the property without the consent of the plaintiffs. So they had every right to file the suit to protect their interest.
Yes. What next? Yes, sir. I'm closing. You want to say something?
Your Lordship concluded after I give a reply. If Lordship kindly see that portion my friend has read just now.
The Evidence Act.
Yes, yes.
Evidence Act.
The payment of consideration.
In the written statement.
Sir, written statement.
Yes, it is open. Sir.
Sir, it says that the consideration was paid to defendant number 6
in the presence of defendant number 5.
Presence of defendant number 5 and one Prabhat Kumar Upadhyay, the son of defendant number 6. These defendants are aware of the fact that the consideration was paid by defendant, some money was paid to defendant number 5 by defendant number 6. But that was a purely private arrangement between defendant number 5 and 6, with which the defendants are not concerned. D5 received the money from defendant number 6 because there was actually defendant number 6 was in possession. Note of possession is recorded in the name of defendant number 5. So D6 wanted to make a claim that he purchased the property from D5 by oral sale. That was not accepted. We also did not accept. We therefore accepted D5 to be the owner. He is to execute the sale deed. D6 was not delivering possession unless he received some money. So that was an arrangement between 5 and 6. He only accompanied and signed the document. That is how the possession was delivered to us. So money has been received. Recital is correct. Mode of payment between them is a different matter altogether. So D5 has not come to the court to say that I have not received money.
Yes.
But D5 may be permitted.
Sir, D5 is not before your lordship.
Yes.
He has not filed any suit for claiming, challenging that I have not received money. So passing a consideration, as has been recited in the sale deed, which has been signed by D5, he acknowledges that I have received. It is a case of which no consideration has been paid. Who says? When the children say, sons say, or 4 sons say, but they implemented D5 as a proof for a defendant or defendant. He has not been examined. No reason has been assigned why he has been withheld from the court.
That's all.
Here, the person knows this is not an admission. This is an explanation, which clarifies the position.
In that explanation, if I may permit it to.
Yes.
Sir, I'll just take. Sir, evidence is there that D5, D6 paid the money to D5. His own statement. Sir, another thing, you should kindly see the right to sue and all those things that has been argued. So kindly turn to Article 254 of the Hindu law, Mullah Hindu law.
हठात मिलियोने अपना कर दियो
बहुत अच्छा 254 Got alienation by father. Got it?
Yes. 254.
254.
Yes.
So the Puruna Bahir एक क्या नस्ल?
नहीं सर अलग
हाँ हाँ. इटा. So 254, 242 दिखा देखते हैं.
निशुन.
254 का सब देखिए. The
alienation by father.
Father's right to alienate.
To father as such has power.
Even the interest of son, grandson, all those things are there. You also may take note of. I'll give the extracts in a separate page in it. I'll give it. So kindly have a look at 241.
Legal necessity.
Legal necessity. My lord. Under these circumstances, it can be legal necessity. Evidence has been laid, he was in need of money and therefore he sold the property. Sir, kindly look at page article 234.
Yes, manager.
Manager. Sir, here father is the manager. And the 254 says father can alienate as provided with the right of the manager to alienate.
Yes.
So all this gives a right. Got it, Lord. Therefore, here a person who has got right to alienate, he has alienated for legal necessity, and he has in the sale deed it has been specifically mentioned about the legal necessity, which has and he has received the consideration money that has been proved, and he admits in the written statement it has been clarified how he has received it. Sir, I will cite two decisions only that it cannot is not open to challenge.
Yeah.
So, for 2021, volume 17, Supreme Court cases 165. But paragraph 30, 31, 32, timetable. The reference statement of absolute yes.
I've gone through that judgment.
Right. Must have. Nowadays, younger people are more
nice. They have gone through that judgment.
And you say that it's not applicable.
Yes, it is not applicable because it doesn't decides the whether the consideration amount was paid or not. That part is to be decided by other modes. Proviso 1 to section 92, as I have cited.
So paragraph 30 has referred to admission defined and other circumstances 91, 92. 31 itself, it could thus be seen that admission given by D1 in his written statement as well as the affidavit in due of examination chief, matter executed so and so, is unambiguous, clear. In the light of this admission by defendant 1, 5, so and so, it will be relevant to consider the effect of section 91, 92. Section paragraph 32, they refer to that judgment Rup Kumar versus Mohan Thezani, elaborately consider earlier judgment of the court. And
the same principle.
Okay.
The same principle.
No, this is relevant, Ballot, for your lordship to see what is an admission and what explanation can be given, to what extent. But here the question is, this non-passing of consideration can only be stated by the person. Because I received the money or not, this is my admission in the document. If another person cannot say he has not received money. I have explained how he has received, what way it has passed. So another decision is what 97 Supreme Court that ancestral property also can be sold by Karta. Is exactly I wanted to solve. Paragraph 11.
For legal necessity.
Right. And this Gangabai and Chabubai, that is 82 Supreme Court, page 20.
That you have already given on the first state.
Yes, that's it. I've given.
These are the judicial. So my respectful submission is that this is the crux of the matter. When the sale deed has been executed, title has passed, they don't have a right to challenge it. On the plea that is an ancestral property, he doesn't have a right to sell. That's the only plea, he doesn't have a right to sell. Sale deed is void. Kindly see the prayer man in the plate. What they have prayed. As such. They could have said for setting aside the sale deed.
Yes.
They say as it's ancestral property, father doesn't have a right to sell. That is the plea on which the entire plate has been filed.
Yes.
And this is a property which is in front of the plaintiff's, the defendant's own house. There's a vacant space, then the road. So therefore, it was necessary for the defendant of 1 to 4 to purchase the property, and they negotiated, and the purchase has been made.
Yes, so that's a nice short answer. What short answer?
The legal
reply of name. Written note. Written.
Shortly legal, whether there was a legal necessity or not, it is very clear from the document itself. He himself.
I will read the document. And you.
It is not for the entire. No, it's not a single word.
Anyway, you make your submissions in writing.
Madam.
Right. Very briefly, only the points.
Madam.
Hearing concluded, judgment reserved. Parties may file the note of submissions and memo of citations, if any, within a week.
I don't know to.
Item number 2, I think it was completed.
He has completed. I am supposed to give my answer.
Yes.
I have
No.
That I will say little facts. Thereafter, the question of law, you want to facts I have stated, you was not.
I think the entire facts was also covered. Everything was there. I had referred to one of my judgments, which
he wanted to reply to.
he according to him, that judgment is not applicable.
No, that judgment is distinguishable.
All right, whatever.
But not only that, only your Lordship judgment, there are other two, our own High Court judgment in the line of your Lordship judgment. And I'll say that those 3 judgments are distinguishable.
That is the only thing you want to point out.
But I'll take your Lordship to the facts, little facts, then we'll say generalized. Let's see this genealogy. The admitted position as described in the plaint itself. Kind of things. Lakshman Barik and Ghasia Barik are 2 brothers. Jambuvati is wife of Lakshman Barik. Then Prahlad and Kiyavati. They are one son and daughter of Lakshman Barik through Jambuvati. Prahlad's wife Sumitra. Let's get that. Now, Kiyavati's son Narayan is dependent number 2. And Kiyavati's husband Narayan is dependent number 2. Son Pradyumna is dependent number 3. From this side, Lakshman's brother Ghasya, his son Trinath is the dependent number 1.
Who is the plaintiff then?
Plaintiff is Sumitra's daughter through her second husband. Second husband's name is Narendra, no? Suresh. Hello. Suresh ko bahala prase. Narendra ko kaso. Sumitra, let me now tell the facts. Now this Sumitra, wife of Prahlad, after death of Prahlad, Sumitra became widow. And she inherited properties of Prahlad as a widow, class 1 heir. Now thereafter, this Sumitra remarried to Suresh Kumar. Some other person comes. Ramesh. I stand corrected. I'm sorry. I'm grateful to my Ramesh.
And his second, her second husband is
Second husband is
Ramesh.
Ramesh. I'm so sorry.
Yes.
Now, through Ramesh, Sumitra has begotten this Annapurna. Annapurna is Sumitra's daughter through Ramesh, second husband. Now, question is,
She is the plaintiff. Annapurna?
Annapurna is the plaintiff.
Yes.
Plaintiff. Nahi? She filed the suit, Annapurna filed the suit for a declaration that she is the only legal heir and successor of Sumitra Bari, and for a declaration that this Trinath from other branch is not the adopted son of Sumitra. For a third declaration that she is entitled to entire properties of Sumitra. Am I clear, ma'am? Now, Trinath, the so-called adopted son, he only contested the issue. The other two persons, dependent 2 and 3, they were set expired. Learned trial court, upon consideration of the disputes and issues involved, declared that she is the only successor of Sumitra. She is the only person entitled to inherit properties of Sumitra, and Trinath is not the adopted son of Sumitra. Trial court decreed the suit as a whole. Now, appeal was filed against that. Who preferred appeal? Lordship will find it. Defendant number 1 and 3 filed appeal.
Yes.
Trinath and Pradyumna son. Pradyumna is the sisters, Prahalad's sister's son. Trinath is brother's son.
No. Trinath is the grandson.
Grandson of Ghassia.
Yes.
Ghassia the grandson of Prahalad Rapu, Bhaira Pu.
No. That's right.
Brother's son of.
Yes.
So, both are class 2 heirs of Prahalad.
Yes.
Both are class 2 heirs of sister son and brother son. They are coming in the category of class 2 heirs of Prahalad. Now, the appellate court, lower appellate court, relying on a judgment of 2002 Supreme Court, gave a finding. Lordship, may kindly see only that part of the finding. Running page 41 of my book. Then your Lordship may see from para 13 onwards, from page 39. Only 1.5 page I will place.
Yeah, the appellate court judgment.
Sir, lower appellate court judgment, only 4 pages.
So that page numbers are not telling.
Internal page 5 dharantu.
Internal page 5. All right.
Para 13 dharantu.
What? Para 13.
Para 13.
Yes.
Peruse the distance.
Yes.
Peruse, sir. Peruse the distance relied on by learned counsel from both the sides. The distance relied on by learned counsel for the respondents are discernibly distinguishable from the present case. The distance relied upon by learned counsel for the appellants reported in year 2002 Supreme Court also resolved the issue at hand. It is profitable to quote in para 12 and 13 of the said decision for reference in the present case here, which are as under. We do not think that the law laid down by the single judge in the above said decision is correct. Even if the female Hindu who is having a limited ownership becomes full owner by virtue of section 14(1) of the Act, the rules of succession given under subsection 2 of section 15 can be applied. In fact, Hindu Succession Bill 1954, as originally introduced in Rajya Sabha, did not contain any clause corresponding to subsection 2 of section 15. It came to be incorporated on recommendations of Joint Committee of two Houses of Parliament. The reason given by the Joint Committee found in clause 17 of Bill, which reads as follows. While reversing the order of succession among heirs to a Hindu female, the Joint Committee has provided that property inherited by her from her father reverts back to the family of the father in absence of issue, and similarly property inherited from her husband or father-in-law reverts back to the heirs of husband in absence of issue. In the opinion of Joint Committee, such a provision would prevent property passing into the hands of persons, this is important, hands of persons to whom justice would demand they should not pass. The source from which she inherits the property is always important, and that would govern the situation. Otherwise, persons who are not even remotely related to the person who originally held the property would acquire rights to inherit that property. That would defeat the intent and purpose of subsection 2 of section 15, which gives a special pattern of succession. Then kindly see, my lord. In case of Dhanishta Kilta, so AIR 2003 Guwahati, this judgment I will cite, my lord. Page 92, it has been held in para 20 as under. Since the object of section 15(2) is to ensure that the property left by a Hindu female doesn't lose the real source from where the deceased female had inherited the property, one has no option but to hold that son or daughter, including children of any predeceased son or daughter of such a Hindu female, will mean the son or daughter begotten by Hindu female from the husband whose property she had inherited, not the son or daughter whom she had begotten from a husband other than one whose property she had inherited. If such property is allowed to be drifted away from the source through which the deceased female has actually inherited the property, the object of section 15(2) will be defeated. In other words, if such a property is allowed to be inherited by a son or daughter whom the deceased female had begotten not through her husband, whose property it was, but from other husband whose property it was not, then section 15(2)(b) will become meaningless and redundant. Notwithstanding, therefore, the fact that a female Hindu becomes a full-fledged owner of the property inherited by her from her husband, the property on her death will pass over to and devolve upon only those sons and daughters whom she had begotten from her husband, whose property she had inherited. If there is no such issue, or if such issue is not alive, then the property, instead of devolving upon sons and daughters whom she might have begotten from another person as husband, will devolve upon the heirs of her deceased husband whose property she had inherited. If, in the view of law as has been settled in this regard, I am not in two minds to say that though the respondent number 1, being the daughter of Sumitra, is entitled to succeed her property, as has been held by London lower court, she in so far as the suit properties are concerned cannot succeed to the same, and those would revert back to the legal heirs of Prahalad, the first husband of Sumitra, if there are any. In view of the aforesaid finding, judgment and decree of the lower court is accordingly varied, hence it is ordered. RFE is allowed in part in contest against the respondent number 1 and 2, but circumstances without any cost. It is hereby declared that appellant number 1, Trinath Varik, is not adopted son of Sumitra Varik. The respondent number 1 is declared to be sole legal heir of her mother Sumitra, but in turn no order to pass. Now, my lord's kindness. There are 3 judgments. One of your lordships, other is my lord Justice Ekarath Haji's lordship was there, and third one is Justice Raghuvir Das Haji's lordship was there. Same supporting your lordship view that the property after she becomes widow under section 14 of the Hindu Succession Act becomes her absolute property, and upon her remarriage, she begets the child. Since the widow is she is the absolute owner of that property on section 14, it will pass to her daughter. Your lordship has interpreted in this way. I am trying to distinguish that, saying that it is little distinguishable. If your lordship will see This 2002 Supreme Court is not the original judgment. 2002 Supreme Court is not the original judgment. Original judgment is Candice 2002. Original judgment is of 1999. 2002 was dealing with a review application. It's a generalist. But instead of taking a lordship to those facts in this 99 and 2002 arising out of the same case, your lordship may see the genealogy in that case. I have tried to frame a genealogy to assist your lordship. What is the point there and what is the conclusion arrived at? But this genealogy is Kehar Singh and Kirpo. Kirpo is widow of Kehar Singh. She travelled from during partition of India and Pakistan. She came to India. As against her properties in Pakistan, she was allotted property here in India. Now Kirpo died, leaving behind two daughters, Santi and Indro. Let's see from the genealogy, it is there. Santi and Indro. Santi died. Santi died. Now Indro had executed an agreement with a person to sell that property which she inherited from Kirpo. Means Indro and Santi inherited the property from their mother. Am I clear, madam? Because 15(2)(a) are in two parts. 15(2)(a) and B. 15(2)(a) says where the lady inherits property from her father and mother, in absence of her son and daughter, it will go back to the heirs of her father and mother. That is 15(2)(a). Here 2B is similar. What is B? Where the lady inherits property from husband or father-in-law, in absence of any son and daughter, it will go back to the heirs of husband or father-in-law. So principal remaining same, only status of the parties are different. Am I clear, man?
No, but I'd like to introduce a caveat here.
Beg pardon?
I would like to introduce this caveat here.
Very correct.
15(2)(a) and 15(2)(b).
Yes.
Similarly worded.
Yes.
It says that if the
only sources are different. Only sources are different.
that the lady who becomes widow and she dies issueless, then the property reverts back to the
heirs of from where she has inherited
of her husband. It doesn't. It stops short of saying what would happen if she remarries. We are concerned with a widow who has travelled up to this place and thereafter remarried. Thereafter,
say in absence of any son and daughter is common in both the.
Sir,
in absence of any son and daughter is common. So question of remarriage son and daughter will not have a very big issue to be dealt with here. What I'm trying to tell is A says that it will go back to the source from where she has inherited. B also says it will go back to the source from where she has inherited.
Yes.
Am I clear, man?
Yes.
Now, in absence of any son and daughter, predecessor son of a son or daughter, that is common in both the provinces.
It will go back to the legal heirs.
That is common in both the provinces. If your lordship sees son and daughter available in A also and B also.
Yes.
B is the distinguishing fact, as your lordship is rightly pointing out. If a son and daughter born through a second husband, that your lordship is trying to tell me. But I will have to convince your lordship. What is the position then? Because A is a situation to arrange for me. Am I clear? So here what happens? Here, Indro, the other daughter of Kirpo, enters into an agreement to sell the property. Right? Now, suit was filed by that very agreement holder for enforcement of that agreement. Now, that suit, if your lordship see that 99 judgment, instead of it. Kindly see. Para 6, 7 and 8. Sir, page 6 of my note देखिए ना judgment देखिए. Note. Sir, अपन note तक दर्शन. Page 6 के देखो ना para 6 में. Copy देना है. ଦେଇଦିଅନ୍ତୁ କପିଟା ଦିଅନ୍ତୁ କପି ନ ଦେଇ କେମିତି କରୁଛ ଅଛି ନାଇଁ ପଚାରନ୍ତୁ ଯଦି କରିବା ବିନା କପିରେ ମୁଁ ଆର୍ଗୁମେଣ୍ଟ କରିବି ନହେଲେ ଯଦି କପି ଦେଲା ପରେ ୟେସ୍ on a perusal of these two subsections we find that their spheres are very clearly marked out. So far as subsection 1 is concerned, it covers properties of a female Hindu dying intestate. Subsection 2 starts from the word notwithstanding anything contained in subsection 1. In other words, what falls within the sphere of subsection 2, subsection 1 will not apply. Sir, two-ta not non-obstante clause start that override with one. One is that A to E, those will succeed the problem. We find that section 15(2)(a) uses the word any property inherited by female Hindu from her father or mother. Thus, property inherited by a female Hindu from her father and mother is carved out from a female Hindu dying intestate. In other words, any property of a female Hindu, if inherited by her from her father or mother, would not fall under subsection 1 of section 15. Thus, property of a female Hindu can be classified under two heads. Every property of a female Hindu dying intestate in general class, by itself covering all properties, but subsection 2 excludes out of the opposite properties the property inherited by her from her father or mother. In addition, we find the language used in section 15(1) read with section 16 makes it clearly the class which has to succeed to the property of Hindu female dying intestate. Subsection 1 specifically states that the property of a female Hindu dying intestate shall devolve upon according to the rules set out in section 16. In case subsection 1 applies, then after the death of Santi, kindly see my lord this genealogy now. After death of Santi, Indro cannot inherit by succession, but it would go to the heirs of predeceased husband of Santi.
Yes.
In present case, it is not in dispute that both Indro and Santi inherited this property from their mother. Hence, they inherited this property as females from their mother. Thus, on the facts of the case, succession clearly falls under subsection 2. Hence, we have no hesitation to hold that on facts of this case, the property would devolve upon after death of Santi, not on the heirs of predeceased husband, but would devolve upon Indro. This legal principle has wrongly been decided by all the courts, including the High Court. Sir, it take a problem that Kirpo, after death of Kirpo, the Santi and Indro jointly succeeded the property. Santi died. Santi's husband's brother claims property as heirs of her husband. They have inherited the property from their mother. So when Indro is alive, daughter of Santi, they say that here this judgment says that Indro will succeed to the property, not heirs of husband. Because it will go to the heirs of mother, Santi. Who is heirs of mother? Indro. Am I clear, man?
Yes, yes.
Right. Now, what happens in 2002? Kindly see. 2002, this Bhagatra, this Santi's husband's brother. देखो से जो
अच्छी judgment अच्छी.
उदेख. Kindly see, he says that I have not been heard, so I should be given opportunity of hearing. 2002 is an offset of 99. He files a review application. Now, in the review application also, the earlier view is reiterated with a further clarification of law. Same way, that it will go to the source from where both Santi and Indro inherited the property, means mother's heirs. But in case of 2B, the same principle is, it will go to the source from where she has inherited, his husband, Prahlad.
Yes.
Now, this theory, if a lordship sees, then Guwahati judgment. I have read that relevant para 20 my lord, I have already placed. So I did not repeat it again, my lord. That is para 20 at page, running page 20 of my note. Now, your lordship see, kindly consider. In your lordship judgment and just judgment delivered by Honorable Justice Rath and whether this aspect has been considered or not. The reason being, what is the object? Then 2002 Supreme Court kindly see. What is the object of the succession? Para 13. Para 12. Para 12.
Of 2002.
Of 2002, page 40.
Yes.
We do not think that the law laid down by the learned single judge is correct. Even if female Hindu who is having limited ownership becomes full owner, kindly see, madam.
Yes.
Section 14 is explained here. Even if she becomes full owner, it will be divested. In full owner, by virtue of section 14(1) of the Act, the rule of succession given under subsection 2 of section 15 can be applied. In fact, Hindu Succession Bill 1954 as originally introduced Rajya Sabha did not.
This has already been read out by you. No, but this does not cover the case of a widow remarrying.
Yes.
It stops at that.
Yes.
I would like you to address the court.
Yes. Therefore, I am addressing.
We'll continue next week.
We'll
continue next week.
Right.
You get my point?
No, this will have a larger impact.
No.
Your lordship judgment will have a larger impact.
No, Mr. Rathore, I get the drift of your argument. You are relying heavily on 15(2)(a) and B.
B with legislative intention.
Yes. Right. Fine. But 2(a) and B particularly. But I would like you to please make a research further that all these decisions are unquestionable. There's no quarrel with the proposition at all because they only relate to a situation where the widow has died issueless. We are concerned with the case. We are concerned with the case of where a widow has gone forward and remarried.
Let us
what would happen to her children?
Yes.
Anyway, so please, maybe my judgment may be wrong.
I never say that. No, but all of us are every day we are educating ourselves. All of us are educating ourselves.
I think this appears to my mind to be the distinguishing feature, very subtle. But you please make research on this point.
I'll read.
For further arguments and part, is this matter next week?
I'll read further, my lord.
Please.
If necessary. Yes, I am sorry.
And there is also a prohibition under section 24.
My case is very simple. It is interpretation of 15(2)(a) and B. And admittedly, Millard, there is no disputed facts in our case. And Prahalad Millard married Sumitra and is issueless. Prahalad died. Be issueless. Thereafter, Millard, the property are Millard in the settlement recorded in the name of Sumitra and Jambavati, the widow. Thereafter, Jambavati died and Sumitra name, the records are prepared. After 7-8 years, she married Rameshwar and got a daughter, that present appellant. Now the question is interpretation of 15(2)(a) and 15(2)(b). That is where Millard Justice Raghuveer Das Millard taken into consideration all the decision and subsequent decision of 2002 also. That is clarified. Even Millard illegitimate child, a divorcee and got the child. And if she got the property from the second husband and they have no child, the original husband Millard, the daughter, that will go to her. That means the intention of the legislature, Millard, as my learned friend pointed out, that initially Millard, the 15(2) was not there while the bill was produced. Thereafter, Millard, joint committee, they have introduced this to protect the interest. And that is elaborately discussed, Millard. Your lordship is Justice Raghuveer Das, that is judgment.
I've seen that. I've seen.
A note also. All the judgments. Give the note and those.
I have also rendered that judgment more or less on separate.
Judgment Millard directly dealt with this point.
In my note, all the judgments are there.
All right. So we'll continue next week. It will come in the week commencing 2nd September.
That will be
next week the package.
That will be really comfortable.
All right.
Item number 3.
We will take up next week.
Your Lordship, I have prepared a note and the two documents.
This was also heard, I think.
Yes, Your Lordship
substantially
had
it was-
said- since Your Lordship had said that, I will conclude today.
Next week, or yeah. Week commencing 2nd September.
Item number 4.
Yeah, please, Your Lordship. So last time we have a lot of discussions over the evidentiary value of unregistered document, my lord. The two decisions which I have. One is
for the other side?
It is Madras High Court.
No, you are the appellant?
No. He is with me.
Who is for the petition? I mean, respondent?
Respondent nobody.
Nobody is appealing?
Notice ही नहीं आई.
Notice, admission? Admission ही नहीं?
आगे.
Admission हो रही थी? अच्छा, ठीक है, कौन?
In one is the Madras High Court, my lord, where they have said that Section 90 cannot be ignored. It has some evidence value. There is a there was among a partial suit, there is an unregistered document, and which one ultimately the Madras High Court has found that coming to Section 90 of the Evidence Act, that is to be given evidence, that is to be followed, and that particular person will get the share over that person.
No, what was the suit for? You are the plaintiff.
No.
You are the defendant. Suit for permanent injunction? Yes. You are the defendant.
I was the defendant.
Yes.
I lose the case there in the trial, and then
suit for permanent injunction. Simpliciter. Yes. Then.
That
What
case
happened?
is that they have purchased that land.
Whether the registered sale deeds executed in favor of plaintiff are valid documents.
And
If there is a registered sale deed.
yes, they say that there is a registered sale deed. They have purchased that land. We say that ignoring our unregistered document, Miller, that has been said. Apex Court also said the same thing, Miller.
So what happened? The trial court dismissed the suit. Declared the suit.
Yes. So the trial court allowed
Declared the suit, right?
against us. We came in appeal, Milord. We
Yes.
lose there, Milord. Because that was the same thing. Has been taken. Here we have come only on the ground that the unregistered document has some evidentiary value over that land. Here the apex court has also taken the same decision, Milord. The apex court has. I am coming to the only on the last part. I am reading paragraph 10 to 13, Milord. Thus, as per provision of section 49 of the unregistered document affecting the immovable property and required by Registration Act to be registered, may be received as evidence of a contract in a suite of specific purpose under chapter of a specific relief act, or as evidence of any collateral transaction not required to be affected by a registered document. At this stage, the primary statement of object and reason to a Tamil Nadu Amendment Act 2012 is also required to be referred to and considered. The primary statement of objects and reasons seems to suggest that amendment has been introduced by the state of Tamil Nadu, bearing in mind the loss of the exchequer as public were executing the documents relating to sale of immovable property, etc., on a white paper or on stamp paper of nominal value. At this stage, it is required to be noted that provision of section 49 came to be inserted by the Act number 21 of 19.
No, I would like to know how the first appellate court has dealt with your unregistered document.
They have said that because it is unregistered, we are ignoring it. That is the only thing.
We'll admit it, we'll see. No. Heard Sri G.S. Namtor, Learned Counsel for the appellant. There is the impugned judgments. Considering the grounds raised, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the courts below were correct, in ignoring the unregistered deeds of sale marked exhibit A and B.
Yes.
Exhibit A and B. Only on the ground of the same being unregistered. Ignoring the
Page 53, exhibit A and B.
A and B, ignoring the effect of section 49 of the Indian Registration Act. That's all. You should notice the respondent here. By registered post, returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR. List this matter November.
Commencing 25th November.
In the week commencing 25th November.
Item number 5.
Yeah, लिखा था
My lord, I have completed point number B. So far as issue for point number 3 is concerned, the trial court framed the issue whether the suit is within limitation or not. Whereas that was decided that whether it is premature or not. Therefore, in order to bring it within the line, I have filed an IA 632 of 24.
It's 92.
Population.
Yes.
That is for recasting of issue number 3. Under Order 14, Rule 5 of the CPC. My lord, submission to your lordship is that date of execution, suit was filed on 21. Date of supplementary agreement, that is payment of consideration, 2 years, 6 months, that is 30 months, not expired by 14/9/2021. BMC approval was given, that is Exhibit P, is dated 25/8/21, but digitally signed 16/9/21.
Yes.
16/9/21.
Yes.
My lord. Status quo order was passed by the civil court on 1/10/21. The defendant firm applied to Orissa for registration on 7/10/2021. Since the authorized agent Akshay Kumar Parija submitted the status quo order before the Orissa authorities, Orissa authorities denied registration on 22/10/2021. These facts are available to your lordship at page 57 and 58 of the RS. 57 and 58. Therefore, submission to your lordship is,
You mean to say it is premature?
yes, it has to be recasted as it is not within period of limitation, but it is to be premature. Courts have also dealt with like that. Orera decision is available to your lordship at page 58 of the brief.
58.
58 of the brief.
Of the second appeal brief.
Second appeal. Internal page 58.
No.
Appeal memo.
No, sir. City year chalichi. 58 achi upon date chart chalichi.
Say date chart.
Oh, date chart katha sir.
Top.
Yes.
ସେଟା ଟିକେ ତା ପୂର୍ବରୁ 22-10-2021 44 item, the Orera authorities passed the following order with respect to the application of the defendant appellant firm for restoration of the proposed project over the suit land. 988 creative. A representation has been received that the promoter has hidden the fact that one civil suit bearing number 1941 of 2021 is pending against the promoter, and the Honorable Court passed an interim order to maintain status quo over the suit property. Therefore, till the matter is settled in civil court, the registration process cannot be continued. Hence, the application is rejected. Therefore, submission to your lordship is, while dealing with issue number 3, your lordship may dispose of IA number 632 of 24, recasting the issue number 3. Now, I invite your lordship's kind attention to page 182 to 184 of the RSA, which deals with issue number 4.
Yes.
And substantial question of law as framed by or formulated by your lordship under code. D, bottom.
Yes.
For that, 182. For that, the learned first appellate court in its judgment at page 26 and 27 held that further as section 55 of the Indian Contract Act 1872, which provides that if someone promises to be done at a specified time and it is not performed at the same time, the contract becomes voidable. If it was the intention of the parties to make time the essence of the contract. In the present case, the contract in relation to real estate business, in which time is the essence of the contract, and the defendant firm has not taken any prompt steps for registration and project approval after reconstitution of the firm, even though considerable period of more than 1 year has been elapsed from the date of the execution of the agreements, nor taken any steps for payment of balance consideration amount to the plaintiff, for which the plaintiff is entitled to rescind the development agreement dated 7/8/2020 and supplementary agreement dated 8/8/2020 and GPA dated 3/9/2020. That apart, since the terms of the agreement are not certain and the agreement is void as per section 29 of the Contract Act. Submission to your lordship is that this is not applicable. Section 55, first of all, section 55 is not of the Contract Act, is not applicable. In as much as the specified period both for completion of construction as well as for payment, completion of payment had not expired by the date this suit was filed. Therefore, I am just inviting your lordship to the language employed in section 55 of the Contract Act. Effect of failure to perform at fixed time. The contract in which time is essential. When party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract, or so much so of it as has not been performed, becomes voidable at the option of the promisee if the intention of the parties was that time should be the essence of the contract. I have already given the two dates for completion of a contract as well as for completion of payment, which has not expired at all. Therefore, submission to your lordship is that the finding recorded by the trial court as well as the first appellate court with respect to on section 55 as well as section 29 are not sustainable in law. Further, my lord, if your lordship sees the language employed under section 29, agreements void for uncertainty. Agreements, the meaning of which is not certain or capable of being made certain, are void. My alternate submission before your lordship with respect to this finding of the courts below on section 55 and 29 is that this was neither pleaded nor proved in the plaint filed by the plaintiff. On the contrary, if we read the language of both the documents, the language is certain, terms are certain, and the period of completion had not expired. Within 1 year of time, we have not only completed all the NOCs required for the purpose, we have made substantial payment of 3 crore 20 lakhs to the plaintiff despite all odds, against all odds, death of my husband as well as COVID-19 restriction. Apart from this payment, the defendant appellant has also spent around 2 crores on different heads. For demolition of the house, number 1, payment to the municipality, payment to the architecture, vetting, everything, and registration of GPA. I will also in my note give the details and date of payments of these amounts. And I have also filed the documents relating to these payments, etc., under Exhibit D to P.
But that is not disputed, I think. 3 crore 20 lakhs. Is it disputed?
Court has decided that it is beyond pleading, therefore I will not accept this document. Therefore, I challenge these findings, and these findings are to be set aside. Now, Lord, so far as substantial question of law formulated under 5 and 6,
Yes.
5 is kindly look to the trial court judgment, page 204 to 249. Whether formulated jota heichi, finding of the trial court under paragraph 13 is liable to be set aside as the same are beyond pleading.
We will go to paragraph 13.
13. Kindly see trial court finding under paragraph 13.
Yes.
Right. One further point of law is brought to the notice of the court as to right of the plaintiff for revocation of the power of attorney. It is the contention of the plaintiff that a power of attorney can be determined at any point of time. As per section 202 of the Indian Contract Act, herein after Indian Contract Act, the relationship between the principal and his attorney resembles the relationship between a principal and an agent under chaplaincy in the Indian Contract Act. It is provided under section 202 of the Indian Contract Act that in absence of express contract, the contract of agency cannot be terminated to the prejudice of the agent when he has an interest in the property. I have already shown to your lordship that substantial property has been paid by the defendant appellant firm to the tune of 3.20 crores. Apart from that, around 2 crores has been spent and considerable time has been spent, labor and time has been spent by the defendant appellant company to start with the project. Therefore, a substantive interest has been created and it is not available to the principal to withdraw the contract. Then next is substantial question of law as formulated by Your Lordship, whether the finding of the first appellate court, the application of a defendant to admit documents under Order 41 Rule 27 suffers from want of due diligence and such rejected. Kindly come to First Appellate Court's finding at paragraph 8, page 263 to 265. The judgment starts from 250 to 280 for this particular finding, paragraph 8.
I've got it.
During the course of hearing of the appellant appeal, the appellant has filed an application under Order 41 Rule 27 of the CPC for adducing additional evidence. The learned counsel for the appellant submitted that the appellant was not aware about the possession of the original documents of the suit land, such as original conveyance deed, GPA, certified copy of the lease deed, mutation ROR, rent receipts, holding tax, water bill, and electricity bill by their firm, for which the same would not be marked as exhibit by the defendant during the trial of the case. And after availing the same, the appellant defendant wants to mark as exhibit on their behalf. The Honorable Supreme Court in the matter of, if Your Lordship will look to the order sheet of the First Appellate Court, this application was filed before the First Appellate Court, and if Your Lordship will look to the order sheet of the First Appellate Court, on the date it was filed and it was submitted by the advocate, that we could not mark it as exhibit because we could not know, we could not found its presence in the office. The recording is there that it will be dealt with in the final judgment. But without making any hearing on this application and without considering the explanation, that I was not aware, that itself is a sufficient reason not to mark it in course of trial. But the same was not considered. Husband died, COVID set in, widow took over management. She was not aware that these documents are available in the office. Therefore, it was could not marked as exhibit in course of trial. She makes an application with avowed reason that it was, she was not appellant aware about the possession of the original documents of the suit land, and such original conveyance deed, etc., should be permitted to be marked as exhibit. Without consideration, this was rejected. Submission to Your Lordship is, this finding in paragraph 8 of the First Appellate Court judgment is to be set aside. Then, my lords, I invite Your Lordship to the language employed in section 100. Unfortunately, it was my fault. I could not point it to Your Lordship that one more substantial question of law
That is not an issue. We can frame it at any time.
Yes, yes. That's why I am bringing it to your lordship's kind notice. Section 100, kindly look to the proviso.
Yes.
I am not reading the whole.
Yes.
Providing that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded, appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such questions. I request your lordship to see the most important issue is issue from trial court. Kindly come to page 209. Trial court.
Yes.
4. IV. Paragraph 5 or IV.
Valuation.
Whether this suit is grossly undervalued or not. What I beg to impress upon your lordship's judicial conscience is admittedly the first document 7/8/2020 Exhibit A and Exhibit 8 says that I have made a deposit lakhs. The second document says the plaintiff's entitlement is 15 crore or 15 lakhs. Law says no doubt the plaintiff can
value his suit to suit.
Value his suit or prayers in the suit. But it has to be at par with the market value. It cannot be grossly undervalued or nor can be given just a skeletal amount. Now, trial court has dealt with issue number 4 at page 242, paragraph 20.
Yes.
Very relevant portion ta tige place karo. कहले जो ऑफिस करने ऑब्जेक्शन so therefore the valuation is in order.
They've got it. No objection by the office of the court has been raised at the initial stage of the suit. In the opinion of this court, the objection raised by this defendant is therefore not acceptable.
Yes. Can office देखेने defect है? Can
yes.
This is available to your lordship as page 2.
Yeah, I've already read it.
Nice.
I've completely read it.
Therefore, and I am citing a decision, one of the Supreme Court and one of our own High Court. Supreme Court reference is 2010, 12 SCC, page 112.
Yes.
Kindly come to paragraph 6. The second proviso to section 7(4) of the Act will apply in this case, and the valuation, this was the declaration and consequential relief of injunction and setting aside it, that the valuation shall not be less than the value of the property calculated in the manner provided by clause V of the said section. Clause V provides that where the relief is in regard to agricultural lands, court fees should be reckoned with reference to the revenue payable under clause A to D thereof, and where the relief is in regard to the houses, court fees shall be on the market value of the houses. Under subclause E thereof. Where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed. But if a non-executant seeks annulment of a deed, he has to seek a declaration that the deed is invalid or non-est or illegal, or that it is not binding on him. The difference between a prayer for cancellation of the declaration in regard to a deed of transfer or conveyance can be brought out by the following illustrations relating to A and B, two brothers. I'm not reading out the explanations. A executes a sale deed in favor of C. Subsequently, A wants to avoid the sale. A has to sue for the cancellation of the deed. On the other hand, if B, who is not the executant of the deed, wants to avoid it, he has to sue for a declaration that the deed executed by A is invalid, void, and non-est, illegal, and he is not bound by it. In essence, both may be using to have the deed set aside or declared as not binding. But the form is different and the court fee is also different. If A is executant of the deed, seeks declaration of the deed, he has to pay the ad valorem court fee on the considerations stated in the sale deed. If B, who is a non-executant, is in possession and sue for a declaration that the deed is null and void and does not bind him or his share, he has to merely pay a fixed court. Here he says the documents executed by him to be annulled by the plaintiff. Therefore, he has to pay, value it at the market rate 15.15 crores and pay court fees on that.
Paragraph 6 and 7 will go to
The Supreme Court decision, paragraph 6 and 7 will take a note.
Yes.
Amma High Court decision ta ekdam recent decision 2024 1 Wheeler 238 Justice K.R. Mahapatra. Renuwala Samantrai and another petitioner versus Manas Ranjan Mahapatra opposite party. In a suit under section 74C, in a suit for declaration with a consequential relief falling under this section, the plaintiff is free to make his own estimation of the relief sought, and jurisdiction has to be ordinarily accepted. But such valuation cannot be arbitrary and must have relation with the real market value of the property at the time of institution of the suit. Paragraph 10 and 11 kindly taken note.
Yes.
Considering the submissions made by learned counsel for the parties and on perusal of the record, it appears that the plaintiff himself stated at paragraph 4 of the plaint that an agreement was executed between him and the defendant number 1 for alienation of the property at rupees 2 crore. Thus, it prima facie appears that the plaintiff has admitted the market value of the property to be 2 crore, but surprisingly the suit has been valued at rupees 1,000 only for the relief of declaration and rupees 100 for the relief of injunction. Then, under no doubt, in view of the authoritative pronouncement of the Honorable Supreme Court and this court, the plaintiff is at liberty to value this suit as per his choice for the purpose of court fee and jurisdiction. What he seeks for declaratory relief in respect of the sale deed in which he is not a party. But it must have some nexus or relation with the market value of the property or subject matter in dispute at the time of institution of the suit. It should not be demonstratively low or arbitrary. When a consequential relief is sought for, along with the declaration, the provision under section 74C of the Act is applicable for the purpose of valuation or payment of court fee. It appears that learned trial court has not taken the same into consideration while adjudicating the matter, and the learned trial court has referred to Article 17 III of the second schedule of the Act, which may not be applicable to the instant case. These material aspects were required to be considered by the learned trial court while adjudicating the matter, more particularly when the same was raised in the petition filed by the defendant under Order 7, Rule 11 of the series. I have shown to your Lordship in our WS, we have taken a specific stand that it has been grossly undervalued. Paragraph 4. The suit is grossly undervalued, therefore the same may be dismissed on this paragraph. With this, I conclude, and after hearing both the sides, I will submit them.
Mr. Bagh will continue next week. Ajay ka time nahi hoga. Tuesday. Tuesday মানে week রে রইব. Week সারা রইব.
কারণ I am preoccupied from 27th onwards. କେବଳ ଆପଣଙ୍କ କୋର୍ଟରେ ଗୋଟେ ଇଲେକ୍ସନ ମ୍ୟାଟର ଆସିବ 27 ରେ, ସେଇ ଗୋଟା କରିଦେଇକିରି ମୁଁ ଆର୍ବିଟ୍ରେସନ ଜଷ୍ଟିସ ବିପି ଦାସ ଭେନୁଆଟ ଭୁବନେଶ୍ୱର ତାଙ୍କର କାଲକାଟାରୁ ସବୁ
କେବେଠୁ କେବେ ଆପଣ
27
when can we take up this matter? September. We commencing second, sorry. Mr. Bagh, we commencing 2nd September. On any day of the week. I think you have to you will make any separate argument, or Mr. Bagh will? এটা একটা প্রতীক হ্যাঁ স্যার আর কোন আছে
I hope your lordship is done for the day.
Well, I should be done for the day. Anything?
I have a prayer.
Yes, please.
But item number 35
35, yes.
and 34.
If there is any urgent matter, I can take
But it's not only a prayer to extend this is a suit for specific performance of contract. Interim stay was there up to a particular date, 2015 order. So SN surface रे जो ହେଇଗଲା ତାପରେ ସେମାନେ କଣ କରିଛନ୍ତି ଡ୍ରାଫ୍ଟ ସେଲ୍ ଡିଟ୍ ପକେଇକି କରି ଦଉଛନ୍ତି ସେଲ୍ ଡିଟ୍ କରିବା ପାଇଁ ବସିଛନ୍ତି ତ ସେଇ ଏଣ୍ଟ୍ରି ମଡେଲଟା ଏକ୍ସଟେନସନ ହେଇଗଲେ ମୋର ଆଉ କିଛି
18 item 35.
item 34. I have filed an application for extension IA number 1497 of 2020.
Let's this matter in the week commencing.
Flag C matter.
Week commencing 9 September, interim order to continue till then.
Right.
May I be pardon to make a mention?
Mr.
Item number 44.
Yes.
Well, the LCR has come. And I would get some parallel documents from Kolahandi. May I pray third week I would get it.
All right. Please this matter in the week commencing 23rd September.
Interim order to confirm.
Interim order to confirm. Yes.
Item 38.
Item 38.
My anxiety is they have sold out the land suit land.
I know you have been waiting for the entire week, but somehow
I'm trying to.
This is the first week where I have not completed the list. Because of I was on leave and there was one.
My lord, the seniors, madam.
No. I was
Take time, madam.
I was on leave on one day and half day. And then one day also was also 19th was a holiday. So practically only 2.5 days we have taken. No list I would have tried my best to complete the list. But I mark that you have been sitting and Mr. Kuntia is also sitting for the entire week. I'm sorry for that, but
No.
next week. Next week,
My lord may take on. No, next week I will not be.
Continue करियो तो please.
I continue କରିବା କଥା କି ତୋର ଆଉ କିଛି ଗୋଟେ ସ୍ପେସିଫିକ ଆର୍ଜନ ହେଇଛି ନହେଲେ ବାକି କଣ୍ଟିନ୍ୟୁ କରିବୁ
Continue करियो.
ନାଇଁ ଏଇ ଲିଷ୍ଟରେ ଆସିବନି ଆଚ୍ଛା ହଉ
9th, we commencing 9th.
2nd September. We commencing 2nd September.
9th.
You want 9th? All right.
Because first these cases should go so that we will be free. Otherwise, we cannot.
No, it will happen. Don't worry, it will reach. Item 38, list this matter in the week commencing 9th September. Yes, Mr. Kuntia, your matter?
बहुत गुटे 41 ଆଉ ଗୋଟେ 32 ଅଛି ମିଷ୍ଟର ଦାସଙ୍କ ପାଇଁ କରି 32 ଆଉ 41
32
ୱିକରେ ଆସି ଯାଉ ମୁଁ ସାରି ଦେବି
week commencing 2nd September. ଗୋଟେ ଆର ୱିକରେ ଆସିବ ଗୋଟେ ଆର ତା ପର ୱିକରେ ଆସିବ
interim order ଅଛି
କୋଉଥିରେ interim order ଅଛି
41 ରେ
but we will continue interim order to continue
32 ବି ସେ ଆପଣ ଦେଖିବେ
ଆଉ ଯାହା ରହିବ ନେକ୍ସଟ ୱିକ୍ ଆଉ ଯାହା
ଦେଖି ତାକୁ ଆଡଜଷ୍ଟ କରି କରିବା
ଆଡଜଷ୍ଟ କରି
35 ଅଛି ଗୋଟେ ରହିବ ନେକ୍ସଟ ୱିକ୍
मल्टीपल असाइनमेंट ही जाउछ त एडजस्ट करिया
पाठाड़ को करतले भी जल्दी आसी जाता सही आता कुछ
नहीं पाठाड़ नही कि पाठाड़ आरंभ हेले मु रखुची से जोडा पाठाड़ होछ एटलीस्ट किछ सरुच किछ
बिना सुनी की
तो माने डिपेंडिंग ऑन द असाइनमेंट सर व्हेन आई वाज हियरिंग एंटीसिपेटरी बिल by 2 o'clock I was finishing 200 matters and this is not possible in second appeal.
Second appeal, nobody is touching, nobody has touched till date.
No.
Slowly.
It is touching. Justice Behra is
sweeping.
नहीं मिसलेनियस असाइनमेंट पे टिके माने एडजस्ट करिया को होउछ
नहीं जहां भी होउछ चली कि बहुत है हां बेटा
is so many assignments are there so in order to
still it is moving
adjust so he has a difficult job in adjusting all these things
that is the problem DRP अंगनवाड़ी रे
DRP अंगनवाड़ी शिक्षा सहायक एजुकेशन बेल एंटीसिपेटरी बेल सब हला
जहां भी देथिले 17 16 रो देथिले मतलब अगेन इट इज extended from 2003
additional election cases
they will begin from 27th
of this evidence
नहीं से हियरिंग को आसीबनी हियरिंग को आसीबो तो आपण जानि छिति
रीडिंग
से 5 वर्ष पर आसीबो
रिजेक्शन ऑफ प्लेट
so we'll take it up, we'll adjust
Make it